Good morning, everybody. Welcome to the Courtroom Files Live. It's a Friday. It's a Super Friday. Let's try to make it a Super Friday anyway. We don't want to turn this into a Monday. Michael Groff filling in for Dan Soul once more for one more day. Then he'll be back, well, maybe, hopefully, on Monday. Otherwise, I'll just stay here into perpetuity. Who knows? But we're going to start our day in a different place today. We'll start with Judge Molly Hennessy Greenwald.
We're here for an arraignment this morning. May I have appearances, please, for the record?
Good morning, Your Honor. David Hobeck appearing on behalf of the defendant, Benjamin Trevorrow, who is in the Zoom courtroom with us as well.
Thank you, Mr. Hobeck. And Mr. Trevorrow, can you please confirm that you can hear and see me and your attorney?
Yes, Your Honor. I'm able to
Thank
see
you.
you.
This is an arraignment, and the purpose of this hearing is for me to inform you of the charge against you, the maximum possible penalty, and all of your rights. You're charged in this misdemeanor complaint with the crime of being a disorderly person by fighting in public. That is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. Do you understand the charge here and the maximum possible penalty?
Yes, Your Honor.
You have a right to an attorney to assist you, and if you can't afford an attorney, one will be provided for you at public expense. Mr. Hobeck is here representing you today. He has filed an appearance in this matter. You also have a right to a trial where you would have many rights available to you. Mr. Hobeck, have you reviewed the trial rights with your client?
Yes, Your Honor. He's aware.
And how would you like to proceed today?
Your Honor, we'll obviously reiterate our not guilty plea. Mr. Trevorrow is actually in the course and scope of his employment as a security guard at this particular facility. So I've spoken with the prosecutor, and I think we will schedule this for either a preliminary hearing or probable cause hearing, whatever your preference is for that as far as the date goes, because I'm optimistic that we'll be able to resolve this pretty quickly.
Okay, very good. So what we'll do is set this for a pretrial conference on December 11th at 9:30 a.m. Mr. Trevorrow, the court has an address for you in Rochester Hills on Lyon Street. Is that a good address?
No, my current address has changed to Lansing area.
Would you provide that address, please?
Yes, Your Honor. It is 3421 West Michigan Avenue.
Okay, and you said that's Lansing?
Yes, Your Honor.
And the zip?
48917.
Very good. So we're going to update that address, and that is where all correspondence from the court will be sent. You need to make sure you monitor your mail there and update the court immediately if your address changes. Mr. Hobeck, would you like to be heard on bond?
Yes, Your Honor. I'm sorry, just to confirm, December 11th at 9:30 a.m.?
Correct.
Perfect. Yes, Your Honor. As I indicated, Mr. Trevorrow was in the course and scope of his employment as a security officer at the bar. He's in the ROTC, the type of individual who shouldn't see in the first place, Your Honor, but certainly won't be seeing again. I'd ask for a PR bond, Your Honor, and quite frankly, no restrictions. I think this is a unique circumstance where there was a potential misunderstanding on the charge. He was just protecting the bar from a disorderly individual who I think you're arraigning this morning as well. So I think under these circumstances, just PR bond and quite frankly, no restrictions.
Okay. Mr. Trevorrow, is everything that your lawyer told me true and accurate?
Yes, Your Honor.
Okay. So obviously I take it as it's represented to me today, but we don't have a city attorney here. I don't know the full facts and circumstances of the case, and I trust that they will be worked out and litigated by two attorneys. In any event, I do have reason to believe that a personal bond is totally appropriate here, and that's just from the objective observations I can make about you. One, you're here today timely and attentively, respectfully for your first court hearing. You've already retained counsel. That counsel has apparently reached out to the city attorney. Negotiations have already begun. That all gives you have a local address and apparently local employment as well, correct? So
Yes,
all those things give me reason to believe that you will always appear for your court dates. I have no concerns there. The other factor has to do with public safety. Obviously, there is an element of force or violence that is part of these allegations here. Nonetheless, they can be addressed through bond conditions. So your bond is a $500 personal recognizance bond. That means you do not have to post any money bail. I'm releasing you because I trust you will come to court as ordered, and I trust you will comply with my bond conditions. And those conditions are as follows. You must appear as directed. You may not leave the state of Michigan without permission of the court. You must not commit any crime while you are on bond to this court. Specifically, you must not engage in any assaultive, harassing, or threatening, intimidating behavior towards any individual. And you may not have any contact with a person named Brett Ashton Beard. And I don't know the relationship, if any, between you and that person, but I'm ordering both, from what I understand from your attorney here today, if that person was the other person on the other side of the alleged fighting, or if there was a co-defendant, I don't know. But in any event, you may not have contact with that individual. Is that clear?
Yes, Your Honor.
Okay, I just need to advise you that any violation of that particular order would subject you to immediate arrest without a warrant.
Yes, Your Honor.
Okay, thank you. Mr. Hoback, anything further from you?
Nothing, Your Honor. Thank you very
Okay,
much.
very good. I just wanted to make clear that those pretrial conferences are held off the record with the city attorney. So
Okay.
you will be in good contact with the city attorney, and then you and the city attorney will update the court by completing a pretrial order before that pretrial date. Obviously, you'll stay in good contact with your client as that pretrial date happens. Any questions about that?
No, thank you very much for that clarification.
Very
good. And so,
Okay.
sorry, just to be clear, so that's just a date for us to get you the pretrial order, not necessarily to meet per se. We'll be in touch before then. Understood.
Exactly. And the city attorney has discretion, you and the city attorney have discretion, whether you want to meet in person, phone, Zoom, however you want to do that. It's just the pretrial order is executed by that date and time.
Excellent. Thank you.
Okay. Very good. Good luck, Mr. Trevorrow.
All right. Thank you, Your Honor.
Thank you.
Mr. Foreman, that's all I have for you.
Okay, I'll hang out till 9:15 in case anyone shows up.
Thank you.
Thank you.
All right. Well, it looks like that is that's gone quiet, and it's a Friday here at the Courtroom Files Live. Michael Groff hanging out. We are filling in for Dan Soul for yet another day here, having a lot of fun. We've been it's been 2 weeks, man. It's been great hanging out with you guys. Thank you so much for all your support. Thanks for everything you guys have been doing. I'm going to be very candid with you guys. It is kind of slim pickings in the courtrooms this morning because it's a Friday. And sometimes Fridays start out very slow, but they can pick up rather quickly. So what we're going to do right now is we're going to head down to Miami-Dade.
Mr. Basiga.
And we're going to say hello to Judge. Not Judge Glazer. It is Judge.
Pull up whoever's waiting. And then the other private
Victoria Siegler. Good morning, Judge.
Boyd. He's number 43 on the calendar on page 12. If there's any other private attorney waiting, please type in the chat who you are here for. And I'm going to, Mr. Okay, be right with you, sir. Spanish interpreters. And we have Mr. Barón helping us out this morning.
Good morning, Honor.
Good morning, sir.
Presidente el abogado. Mr. Torrealba.
I'm calling this morning the case of Gustavo Torrealba.
Señor Gustavo Correalba.
And is there counsel representing this gentleman?
Daniel Lurvy on his behalf.
Acaba de presentar el abogado defensor.
Good morning, Mr. Lurvy.
Good morning,
Have you
Judge. How are
had
you?
a chance to read the arrest affidavit yet or not?
I have.
Okay.
El abogado ya leyó el informe del arresto.
Judge, I know it's a burglary with an assault. I had sent a
Matter of law.
Ms. F.
Señoría, yo sé que es un ingreso ilícito con intento de agresión.
I was hopeful that she may agree to a bond. He was doing a little self-help, going to tools from somebody that he knows. He was allowed in, and then at worst, it was a push and shove.
Entonces él estaba haciendo un trabajo por cuenta de él, le dejaron entrar y en lo que se entiende hubo una situación donde hubo un par de empujones.
I'm told he has no priors, but I have not been able to confirm that.
Él me dijo que no tiene antecedentes penales, pero todavía no he podido verificar eso.
He knows the alleged victim. His wife, who was with him, is the real estate agent who rented the, I guess, studio to the alleged victim. And my client loaned him some tools and then went back to get them. And that's when the pushing occurred.
Entonces él conoce a la presunta víctima, la esposa es la agente de bienes raíces que estaba ahí, le había prestado unas herramientas, regresó y ahí fue cuando ocurrió la situación.
Certainly the type of matter that in division they ultimately will stipulate to a bond. I hate to make them sit waiting for an Arthur hearing.
Entonces este tipo de situaciones yo sé que pudiera dar aprobarse una fianza para que no tengan que esperar ahí esperando una audiencia para ver si le autorizan a excarcelamiento.
That's all.
Sería todo.
Ms. F., were you feeling inclined to stipulate to the court, ignoring the non-bondable status and setting a bond?
La juez pregunta si de hecho es una situación en la cual pudiera presentarse a que no haya fianza.
Judge, counsel's right. I don't see any criminal history. And I see that counsel's right. I don't see any criminal history. And I see that the defendant's 61, but there is probable cause. I'll leave it up to you, Judge.
Señoría, sí, el abogado tiene razón, no hay antecedentes penales, el acusado tiene 61 años, pero hay motivo fundado, lo dejo a su discreción, señoría.
Judge, I'm pretty certain that a stay away order will be sufficient. He's a legitimate guy, hardworking. He's from Argentina originally, has lived here for decades, has a wife. I'm not certain if he has any children, owns property, and with a stern warning of the court not to go back to that location or to have contact with the victims will absolutely suffice with whatever monetary bond the court thinks is appropriate.
Señoría, yo pienso que la orden de alejamiento sería suficiente. Él es un hombre que trabaja duro, él es de Argentina, él tiene su esposa, no estoy seguro si tiene hijos, tiene propiedad acá. Yo pienso que es suficiente con la orden de no regresar y que se mantenga alejado de la víctima.
F, could be my ears. It could be the fact that your speaker is fuzzy. Was that you will allow the court to set an appropriate bond? Thumbs up.
No,
or
up to you,
the court,
Judge.
All righty then. So in this matter, I'm going to make a finding that Mr. Torrealba, I'm going to set a bond for you.
Señor Torrealba, voy a fijarle una fianza.
But there are some conditions of this bond that you are going to have to follow.
Pero hay unas condiciones que usted tendrá que seguir para que se haga esta fianza.
You are prohibited from having any contact with Lucas Alvarez or Vladimir Sanchez.
Usted no podrá tener ningún contacto con Lucas Álvarez ni con Vladimir Sánchez.
This means in person, directly or
Eso significa ni en persona, ni directamente, ni indirectamente.
In writing, by telephone,
Ni por
pager, or
escrito,
fax.
ni por teléfono, ni por fax, ni por pager.
You cannot contact these people through third parties.
Usted no podrá contactarlos tampoco a través de terceros.
You must stay at least 500 feet away from the alleged victims.
Y en todo momento tendrá que mantenerse por lo menos a 500 pies de distancia de las presuntas víctimas.
Their home, their place of employment, and or any other place you might encounter them.
Donde estas personas vivan, donde trabajan o en cualquier otro lugar donde se las pueda encontrar.
You cannot have any electronic contact such as emailing, texting, social media, twittering, twerking, any of those things.
No podrá tampoco contactar a estas personas por ningún tipo de medio electrónico, ni por redes sociales, ni por texto, ni por Twitter, ni por nada de eso.
And you must stay away from 2050 Southwest 22nd Street at all times.
y en todo momento tendrá que mantenerse alejado del 2050 South de la 22 Street en todo momento.
Mr. Lurvy, you're the moving or the begging party, as we might call it. What bond
ma'am.
would you suggest? And then we'll give the state an opportunity to respond.
Entonces estás preguntando a la jueza del abogado que sugiera que se haga a continuación.
Judge, I would request a $10,000 bond from my understanding of his financial wherewithal.
Señoría, yo pediría una fianza de $10,000.
Without waiving any objections to the court setting a bond, Ms. F., what is your reaction to $10,000?
¿Qué piensa la fiscal de los $10,000 de fianza?
I think it's reasonable.
Es
Bond
razonable.
is set at $10,000. A stay away order has been issued and read.
Entonces se ha leído la orden de alejamiento, la fianza queda de $10,000.
Anything else, Mr. Lurvy?
No, Your Honor. Thank you very much for your time, and thank you, State. Have a great day, everybody.
¿Algo más? No, no hay nada más.
Now, I'm hearing I had another case, Mr. Anthony. Oh, you are so good. Lucky me. And now to corrections. I have moved out a turn off page 53 to a Anthony Boyd Jr.
Your Honor, we have to go pick him up. We don't have him.
All right. To counsel who's waiting for Anthony Boyd, corrections understands we're looking for him, and as soon as he is available, we'll call him back up.
Okay, thank you, Your Honor.
All right. Now let's see. I will return to the calendar. I have a case of Lakeisha Williams, who is not brought to court today. Let's see.
Ms. Court, you want to have the judge set about?
As was found yesterday. Now what? To court today. She wasn't brought to court yesterday when probable cause was found and the public defender was appointed.
Waiver presence at this point, Judge.
All righty then. It's a firearm possession by a convicted felon. On what bond they would like to see? Defense? 5,000 it is. Thanks for coming. Next up, we have the
All right, it's the
matter
Courtroom Files Live. It is a
Middleton.
Friday. We got courts coming up on the line here. We'll check back in with Miami-Dade at some point here. And this is Judge.
It's my understanding that the defendant will plead guilty to count one, operating while intoxicated. Third offense, and there's a Killebrew agreement to sentencing into sobriety court, and the people are going to dismiss the additional charged counts 2 and 3.
Thank you. Mr. Harrison?
That directly comports with my understanding as well, Your Honor. Thank you.
Thank you. Mr. Peterson, is that how you wish to resolve this file today?
Yes, sir.
Please raise your right hand. You may remain seated. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You may lower your hand. Mr. Peterson, looking back on June 27th of this year, were you on probation, parole, or bond at that time?
I was not.
All right. You are currently charged on what's called an amended felony information with 3 counts. Count 1 is a charge of operating while intoxicated or impaired as a third offense. As a third offense, that becomes a felony punishable by a minimum of $500 to a maximum of $5,000, and then either a minimum of 1 year to a maximum of 5 years in prison, or in the alternative to that, a minimum of 30 days in jail to a maximum of 1 year in jail. At least 48 hours of those jail times must be served consecutively, and a minimum of 60 to a maximum of 180 days of community service, plus rehabilitative programming, costs for prosecution, reimbursement to the government for any emergency response, and expenses for prosecuting the defendant. Plus, there's mandatory vehicle mobilization of not less than 1 but not more than 3 years. All right, I'm told today that you're going to enter a plea of guilty to that, and there's going to be an agreement as to the sentence portion, but I'll get to that in just a moment. Count 2 is failure to report an automobile accident. That is a misdemeanor punishable by up to 90 days and or up to $500. Count 3 is a charge of operating while your license was suspended, denied, or revoked as a second or subsequent offender. That is a misdemeanor punishable by up to 1 year and or up to $1,000. Both of those last two counts will be dismissed. There is also what's called a Killebrew agreement regarding what the sentence would be. A Killebrew agreement is an agreement made between the defendant and the prosecutor. I'm not a part of that agreement. Now, and the agreement is that at the time of sentencing, the court will place you into sobriety court. And if it means you could withdraw your plea and come back to this stage of the proceedings. When someone is sent to sobriety court from this court, the sobriety court is handled in the district court, and the case is set for a delay. So for a year, you go down, participate in the program, and then after that year, it comes back up, and they give me a report telling me, hey, he's done a great job, he should continue. You go back and serve a year if that's what I do. And when I do that, your plea is reduced from an operating while intoxicated third to an operating while intoxicated second. In that instance, that is a misdemeanor punishable by up to 1 year and or up to $1,000. Additionally, in both instances, the state of Michigan through the Secretary of State may take some additional license sanctions, but that is done outside of this court. Now, when if I do send the case to sobriety court and the case comes back after a year, it's up to me to determine if I keep you in the program. They might say, hey, judge, we want to keep him in the program, even though he has violated the rules 20 times, just as an example. I might say, yeah, I appreciate your advice. No. So I still get the case. And if at that time you're failing the program, at least I determine that you are, then you're stuck with the plea to the drinking and driving third. So what's going to happen here is if I accept this plea today, we're going to set it for sentencing. Sentencing will be in about 5 weeks. We do them on Monday mornings. In the meantime, the attorneys and you are going to apply to the sobriety court program, and then I should get a letter saying, yep, he's in it. And if he's in it, I'll probably put you into the program. I don't know if I'm going to yet, because the reason why I don't do agreements where I join the sentencing agreement right now, I don't really know anything about it. And there's going to be a report prepared between now and the time you come back to court, and I determine if I'm going to put you in the program. And in that report, they're going to go over your criminal history, and they might find out that you are wanted all over the world as a spy. But anyways, it's just an example. You might be. And so that's why I don't agree to it, because I often find out the attorneys may not know everything about me. And so that's why I don't agree to it. But presumably, you'll probably will go into the sobriety court program. Does that all make sense?
Yes, sir.
All right. Do you need me to repeat any of that?
I do not.
Great, because I rambled on quite a bit. Good. Now, by entering a plea of guilty today, you're going to waive certain rights and not have a trial. You'll be given up the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have its silence used against you, and the right to testify if you were to choose to testify at that time. You understand those rights, Mr. Peterson?
Yes, sir, I do.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you'll be forever waiving those rights as they apply to this particular case?
Yes, I do.
Additionally, any appeal as to conviction and sentence pursuant to this pretrial agreement would be by filing what's called an application for leave to appeal and not a claim to appeal by right. The differences are relatively minimal, but they're important. If you were convicted at a trial, the appellate court has to entertain your appeal. That's the difference. Furthermore, you may be given up the right to appeal issues that would only be appealable if you were convicted after a trial. Also, you'll be given up the right to claim that the plea today was a result of any promise, threat, or inducement we have not discussed. Other than the terms of the pretrial agreement, have there been any other promises, threats, or inducements that we have not yet talked about?
No, sir.
Okay. Now, I know Mr. Harrison's probably talked to you about Michigan sentencing guidelines, how they apply to felonies. He's obviously talked to you about the sobriety court program. And I've just told you, I have to have them tell me you're in the program. I can't send you down there until they say, yeah, we'll take it. But other than all that, has there been any other promises as to exactly what the court punishment or sentence would be?
No.
All right, knowing all that, do you still wish to enter the plea as we discussed earlier?
Yes, sir, I do.
As to count one, operating while intoxicated is a third offense. How do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what it is that you did that makes you guilty of that offense. Turning your attention now to June 27th of this year. Well, it looks like it's Herring Township and Cherry Grove Township here in Wexford County. Were you operating a vehicle?
Yes, sir, I was.
And it looks like you were operating a vehicle at one point in time, looks like out on North Mitchell Street. Is that right? Now it's 1:30. All right. How it says Cherry Grove.
There was a prior incident alleged to have occurred earlier in the evening that quite frankly has formed the basis of count two.
I'm just focused.
We just do venue in here.
Exactly.
We're gonna do Herring Township. Great. So you were out on North Mitchell Street, also known as our Main Street, which extends to the north end out in Herring Township. And were you stopped by law enforcement?
It was,
Or there was an accident?
I was stopped.
Okay, thanks. And prior to operating that vehicle out on that date and time and location, had you consumed some alcohol?
Yes, sir, I did.
And at the time you stopped, there must have been either a data master or an intoxilizer or a blood draw. Mr. Carnes, what was it?
Yeah, Your Honor, it was a blood draw at 0.257.
Mr. Harrison, does the defense so stipulate for the taking of the plea and the sentencing, sir?
We do.
Thank you. Also, Mr. Peterson, is it true that on June 4th, 1997, in the 84th District Court here in this county, you were convicted of operating while intoxicated then?
Yes, sir, I was.
Is it also true that you were a person under the age of 21 back on June 1st, 1999, and you were convicted of operating with a blood alcohol content between 0.2 and 0.8 in the 84th District Court in Missaukee County?
Yes, sir.
Thank you. Mr. Carnes, do you believe the defendant provided a factual basis?
Yes, sir.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe that the court is in compliance with Mr. Cole 6.302?
Yes, sir.
Mr. Harrison, do you agree with all that?
I do.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record, in addition to the stipulation as to the blood draw results, satisfies the evidence for count one. Therefore, the defendant is found guilty of that offense. The remaining two counts will be dismissed at the time of sentencing. Mr. Peterson, I'm about to release you on your bond still, unless Mr. Carnes, you don't have any objection, do you?
No objection, Your Honor. I just remind the defendant he has one strike on the bond for
Yeah,
late test.
I remember.
So that's
Okay.
it.
Yeah, so I'm gonna release you on your bond. Let's be obvious here. You don't want to violate your bond between now and the time I sentence you, because I may not go along with the sobriety court concept. You got it?
I do.
All right, good. Let's make sure you're staying clean. Now, when you leave this courtroom, you're gonna go down to the probation and parole office. That's on the first floor. I assume you've been to community corrections. Is that right?
Yes, sir.
stand in front of Community Probation or Parole Office. They're going to give you a packet. You're going to follow the instructions inside of it and turn all that in. And you're going to fill it out with a lot of information. Make sure you're as complete and accurate as possible. Next, they will schedule an interview with you, and you have the right to have Mr. Harrison present at the time of that interview. And number 3, Mr. Harrison's going to need to meet with you prior to coming back to court for sentencing. And he needs to go over that report with you. Each party has the right to ask for corrections, make objections to the content of the report prior to the court using it for sentencing. So you need to make sure you stay in contact with your defense attorney. Do you understand?
Yes, sir, I do.
Okay. Now, this report that I just discussed will describe the pre-trial agreement. It will include any statements, information you make or provide. It will also discuss what happened in this particular case on that day. It will also talk about prior criminal history. It will include scoring to the guidelines, which again are not mandatory, and it will also make a recommendation. That recommendation is merely that. It is a recommendation, as it is me alone who determines what the sentence is. Do you understand?
Yes, sir, I do.
Do you have any questions, Mr. Peterson, about what we have done today?
No, sir, I don't.
All right, we do sentencings on Monday mornings in this court. I can predict yours will probably be in about 4, potentially 5 weeks, because we have some holidays coming up, but it should be sometime in the middle of December, I expect. Anything further from the people today, Mr. Carnes?
No, Your Honor.
How about you today, Mr. Harrison?
Nothing further, Your Honor. Thank you very much.
Thank you. Mr. Peterson, you are hereby excused. You may go down to the probation and parole office.
Sure.
Thank you.
It's TCF Live. It's Friday. It's a super Friday. Well, you know, we're doing our best to get through. And we are wishing Beth a very, Beth, Dan's wife, is in our thoughts today. I don't know if you caught it on the pre-show, but Beth had, Beth's not having a good day. Let's just put it that way. More information on that later. But needless to say, we do hope that Beth and Dan and family return safely. They will sooner or later from their vacation, and he'll return to this seat. All things likely on Monday. So, in the meantime, I'm filling in, having a great time on a Friday. Courts are pretty quiet. We got Judge Simpson doing landlord-tenant. We all know that can be a little bit, sometimes it's not always the most exciting content. Although in Judge Simpson's court, we all know that landlord-tenant can go a little interesting and sideways. So we're going to keep an eye on what's going on over there in Judge Simpson's court. In the meantime, let's see what's going on with Judge Middleton this morning. Looks like he's got maybe a sentencing. I don't know what's going on here, but let's find out with Judge Middleton.
All right, I think I've got everything I need here. This is Jesus Medina, or Antonio Jesus Medina Rubio. Is that correct?
Este es el caso de Antonio Jesús Medina Rubio, ¿es correcto?
Sí.
Yes.
You are charged with operating while intoxicated.
Usted enfrenta el cargo de conducir en estado de ebriedad.
Driving with a suspended driver's license.
Conducir con una licencia suspendida.
Well, let's back up.
Vamos a retroceder.
The operating while intoxicated charge was on July 27th.
El cargo de conducir en estado de ebriedad fue el 27 de julio.
The other charge is driving suspended.
Los otros cargos, conducir con la licencia suspendida,
Drag racing,
hacer carreras
and speeding
y exceso de velocidad.
occurred on September 10th.
Ocurrieron el 10 de septiembre.
We have with us this morning our certified court interpreter, Vivian Montero.
Tenemos con nosotros hoy nuestro intérprete certificada jurídica, Vivian Montero.
She's going to assist us this morning.
Ella nos va a ayudar esta mañana.
Ms. Montero, would you please raise your right hand? You affirm to the best of your ability, you interpret these matters from Spanish into English and English into Spanish.
I do.
And would you state your name, please?
Vivian Montero, court interview 189.
Kind of broke up there.
If you want to have my camera, you're on. Feel free to do so. Zoom change.
All right,
I can't shut my camera off, so.
maybe I can shut it off. No, I can't. All right. Mr. Gibson, it looks like the defendant is going to plead to a charge of impaired driving.
Licenciado Gibson, parece que el acusado va a contestar culpable a un cargo de gravedad reducido que se llama conducir con las facultades disminuidas.
And to drag racing
Y al cargo de hacer carreras.
and speeding.
Y exceso de velocidad.
Is that true?
¿Es verdad? Yes.
What? Sorry about that. Well, let me ask this. What is your understanding of the plea agreement?
Déjame hacerle esa pregunta. ¿Cuál es su comprensión del acuerdo?
I do. Was that offer that the city of Sturgis made, is it to plead as charged?
El
Yes,
acuerdo
the
que
city, I'm sorry.
en la ciudad de Sturgis es para que conteste culpable tal y cómo se le acusa.
In the drinking driving case, the county prosecutor has agreed to reduce drunk driving to impaired driving.
En el caso del condado, el agente del Ministerio Público está de acuerdo con reducir la gravedad del cargo de conducir en estado de ebriedad a lo que se llama conducir con las facultades disminuidas.
That is the July 27th incident in file 252091.
Esto es el incidente que ocurrió el 27 de julio en el caso 25-2091.
Regarding the September 10th incident,
Sobre el incidente que ocurrió el 10 de septiembre,
those are written under city ordinance.
esos están bajo la ordenanza de la ciudad.
And Mr. George is here on behalf of the city of Sturgis.
Licenciado George está aquí por parte de la ciudad de Sturgis.
He would agree to dismiss the no operator's license
Él está dispuesto a desestimar el cargo de no tener licencia vigente
if the defendant pleads to drag racing and speeding. Is that
Si el
correct,
acusado
Mr. George?
contesta culpable de hacer carreras y exceso de velocidad. ¿Es correcto, licenciado George?
No, Your Honor.
Okay.
No, su señoría.
We would offer that we would dismiss the drag racing charge for a plea to the speeding ticket and the no valid odds.
All right, they've got it backwards.
Estamos ofertando a desestimar el cargo de hacer carreras. Y si él contestara culpable a no licencia y exceso de velocidad.
That's a deal because drag racing carries 6 points and requires that your license be suspended.
Eso es un buen acuerdo, porque hacer carreras conlleva 6 puntos en su historial de conducir y requiere que se le suspenda la licencia.
Yeah, Mr. Zambrano, the prosecutor's going to meet with you out in the hall, I think is the deal. All right, so let's talk about that. Impaired driving is a lesser included charge of operating while intoxicated.
Conducir con las facultades disminuidas es un cargo de gravedad reducido de conducir en estado de ebriedad.
Carries a fine of $300 maximum rather than $500.
Conlleva una máxima penalidad de $300 en lugar de 500.
Carries 4 points rather than 6.
Conlleva 4 puntos en su historial de conducir en vez de 6.
And if you had a valid license, it would allow you to have a restricted license.
Y si tuviera una licencia, podría solicitar una licencia con restricciones.
The no operator's license is a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100.
El de no licencia conlleva una máxima penalidad posible hasta 90 días de cárcel y una multa hasta $100.
A speeding charge
Exceso de velocidad
is a civil infraction that carries a $160 fine.
es una infracción civil y conlleva una multa de $160.
Do you understand the charges?
¿Entiende los cargos en su contra?
Sí.
Yes.
Are you going to plead to those charges?
¿Va a contestar culpable a esos cargos?
Sí.
Yes.
Your Honor,
Anybody
if I-
threaten you to get you to try to plead to those charges?
¿Alguien le prometió algo para que contestara culpable a esos cargos?
No.
No.
Your Honor, may I just briefly talk to my client for a second off the record? I've got someone here that can help me do the interpretation in the room with me.
All right, let me put you back in the breakout room.
Well, I don't think I need a breakout room because like I said, it'll just take a second and I've got someone here in the room that can.
All right, let me put you in the waiting room for a moment. All right, thank you, Vivian. Thank you for your patience. Takes 3 times as long to do every case through an interpreter. So we have to speak slowly and in small sentences, and it just takes a while. Ms. Snyder, who's your lawyer? Have we got Ms. Snyder's case resolved? No. Well, I'm gonna do her in a minute. She's got her infant with her in here. We'll let her get up. Well, she seems to be, but last time I saw her, she was about 5 months. So what is she now?
She'll be 7 on
They grow awfully fast. All right, let me bring it back.
It's TCF Live. It's Friday, and we're just hanging out with Judge Middleton in the midst of a plea agreement and interpreter and all that, and they're waiting for everyone to come back. Looks like they're back. Here we go.
¿Listos?
Well, that never happened before.
Or not.
Laura, Paul just somehow disconnected the Zoom room.
It's nice to know that See, it isn't just me that has the technical issues. It's all these courts. We've been watching this all week. It's not always a smooth operation. So we're just going to hang here with Judge Middleton for a while. And the reason we're doing that is because we have a couple other places we can go, but we want to kind of see how this goes. We don't like to kind of cut it off in the middle of a hearing, assuming that this hearing will continue. We'll see, but
Okay, there you go.
here we go. Maybe.
All right. Mr. Gibson, are you ready?
Licenciado Gibson, ¿está listo?
Are you ready? Is that acceptable?
Sí, estás de acuerdo.
Okay, yes.
Eso es- Yes.
All right. I have an advice of rights here somewhere.
Tengo una notificación de derechos firmadas aquí.
Other than this plea offer, Senor Medina Rubio, did anyone promise you anything?
Fuera de este acuerdo, señora Medina Rubio, ¿alguien le prometió algo para que contestara culpable?
No.
No.
Or threaten you?
¿O le amenazó?
No.
No.
Let's talk about the drinking driving case from July 1st.
Vamos a tratar el caso de conducir en estado de ebriedad del mes de julio. Primero,
If I can find it.
a ver si lo puedo encontrar.
¿Fue cuando tuve el accidente con la camioneta negra?
Is that when I had the accident with the black truck?
Yes.
Yes, sí.
Ese caso, un abogado de Sturgis me lo arregló, ya había estado libre con ese caso.
As Sturgis attorney resolved that case, and
All
it's
right,
been
well,
closed.
just a minute. Let me get up to speed here.
Momentico, por favor. Déjeme ponerme al día.
All right, in that case, it is alleged that you were driving a car on Flock Road near Fuller Road out in the country.
Se alega en este caso que estaba conduciendo sobre la calle Flock, cerca de la Fuller, en el campo,
And that you had an unlawful blood alcohol level
y que usted tenía un nivel de alcoholemia no aceptable.
In this one, the vehicle went into a swamp.
En este caso, el vehículo se metió en como un laguillo.
Sí.
Yes.
All right, do you remember that night?
¿Se acuerda aquella noche?
Sí.
Yes.
Where were you going?
¿A dónde iba?
Para la casa, venía de la granja, fui a prender unos sprinkles para regar un cuarto que lo iban a lavar otro día y ya llovió para la casa. Entonces el volumen del alcohol que traía, yo traía una cerveza en el carro. Cuando salí de la granja, allí me la tomé y allí dejé el bote y me fui.
Stop. You have to speak in short sentences.
Tiene que hablar pausadamente. I was heading home. I had a beer at the farm. From the farm, I was going to pick something up. And from there, I was going home. That's
So you
what
had more than one beer.
Usted había tomado más de una cerveza.
Pero de una caguama de 24 onzas.
Oh, but it was a caguama. ¿Y eso es de cuánto onzas? ¿De 48 onzas?
24.
It was a 24-ounce caguama beer.
Well, they gave you a preliminary breath test and was 0.130.
Cuando le dieron la prueba de alcoholímetro, con el alcoholímetro, realmente salió a punto 1.30.
Made you drive into a swamp.
y le hizo meterse en un laguillo.
Ah. Fue quizá a lo mejor, yo creo que a lo mejor era el licor de la noche anterior.
Maybe it was the alcohol from the night before.
Well, perhaps.
Tal vez.
That may explain it.
Eso puede explicarlo.
Either way, you were pretty good. No.
De todas maneras, usted andaba bien borracho.
Mr. Gibson, are you available on December 8th for that?
Licenciado Gibson, ¿está disponible el 8 de diciembre para eso?
What time? I have a status conference at 9:30, but other than that.
This would be at 11.
Yes.
Eso
that would
sería
be
la
good.
tarde.
All right. Now, let's talk about the other case.
Ahora vamos a tocar el otro caso, tocar el tema del otro caso.
In that case, it is alleged that you were driving a car in Sturgis on September 10th.
En este caso, se alega que estaba conduciendo un auto en Sturgis el 10 de septiembre.
And that you did not have a valid license at that time.
Y que no tenía una licencia vigente en ese momento.
Is that correct?
¿Es correcto eso?
Sí, es correcto.
Yes, that's correct.
And you were speeding. You were going.
Y iba a exceso de velocidad.
63 and a 35. You accept that?
Usted viajaba 63 millas por hora en una zona de 35. ¿Acepta usted eso?
Just a minute. Was Mr. Thal in on that meeting? The White Pigeon attorney? Okay.
You talked to him.
All right. I'm sorry, Vivian.
He said yes.
Were you going at least 63 miles an hour in a 35-mile-an-hour zone?
Viajaba por lo menos 63 millas por hora en una zona de 35.
Pues mi carro es viejito, no creo que haya subido tanto, casi unos mínimo 50.
Well, my vehicle is kind of old. I don't think it could travel that fast. I'm thinking maximum 50.
All right, we'll sort that out. It says you were going 63. We'll set that all for sentence on December 8th.
Vamos a postergar todo eso para la imposición de la condena el 8 de diciembre.
El 8 de diciembre.
So December 8th.
Yes.
Que sí. Okay.
All right. The bailiff's going to give you some paperwork. I want you to take it out to the counter, and the clerk will give you the paperwork to be back here on December 8th. And Vivian, it appears we're going to need your help again on that day.
Okay. Me va a dar los documentos que los lleva a la ventanilla y ellos van a entregarle otros documentos para regresar el 8 de diciembre.
All right, you're free to go.
Ya se puede retirar.
I don't believe we have any other interpreter case today, so thank you.
Thank you, Your Honor. Have a good
Thank
day.
you.
All right. So that is what is happening over in Judge Middleton's court right now. We'll probably head back over there. As I said, it's a Friday, and things can be kind of quiet in courtrooms on Fridays. That being said, I suppose what we could do right now is we could head over to Judge Stevens. Looks like he's got another contestant coming on down, so we'll take a look. We'll take a look at what he's got going on over there. Say good morning to Judge Stevens. Oh boy. Well, we'll say good morning to our first audio glitch of the day is what we're going to do. That's unfortunate, but it is a Friday. It's a super Friday, but we're battling things out here on a Friday, everybody. Oh my goodness, that's just the way it goes. All right. Hey, Michael Groff filling in for Dan Soul. It's good to be here with you. The chat, we got Barbara, we got Wahoo, we got people, we got Austin. I think Austin's over there. Ashley's in the chat. We got a lot going on over there, so hopefully everything is good. All right, I think we've got the audio all fixed up, so we can now resume with Judge.
Yes, sir. Judge, she was
Stevens.
reset a couple weeks ago. We had come in and asked.
Where is he?
She's here.
Oh, it's Camilla.
We had asked the court to amend one of her bond conditions, contact with the complaining witness, because it's her son. The court wanted her to take a parenting class, which she has been doing. She is currently in week 4, I guess approaching week 5 of 12 with the Faith Tabernacle Ministries parenting class. She's been doing great work there, apparently, talking to the people there. And so we reset it today so the court could see that she has been taking parenting classes because
what does that do from, I don't.
The reason they're bringing this all up is this is a special needs child that has trouble with people controlling the child. And so I think she lost her temper during one of the uncontrollable moments, and that's what caused all this. And so we wanted her to take parenting classes to learn to deal with this situation.
Before disposition?
Before we gave her permission to be back around the child. Which, and I think the case may, once she does the parenting, we may actually dismiss it. We're discussing that. But right now.
How long is this going to take?
she has.
The last day will be December the 28th.
Okay. Next month?
Yes, sir.
Yeah,
Right.
it's a 12-week spray.
Yes, ma'am. Okay.
But we've had calls from the grandmother asking, well, please let her back in because they're having trouble controlling the child. So we're in that little quandary of she hasn't completed what she needs to complete, but
She's completing it.
she's working on it.
One thing she can't do is speed up time.
The only solution I could think of is if we make sure someone else is present during the times that she has the child. Make it like a supervised visit. That way we have somebody there that if things.
I think weaning this relationship back into order is the way it's going to have to happen, one step at a time. But this is, taking those classes should be finished in December. Before then, what are you asking for?
Just we were reviewing, we just need her to be able to come get her son again because the school or the surrounding family is just unable to control him. And his mom, the child's mom, Ms. LeBeau, is apparently, historically speaking, the only one that's been able to manage him with any degree of success. I understand the situation, but at the same time, everyone in the community around this child is begging for her to be able to have her son back.
Anything else for you?
Nothing. I suggested that if we're going to do that, that it be like supervisor, somebody with her, another adult with her, to make sure that if there's something that looks like it's going wrong.
Take more than just half the population of the planet to be eligible to do that. We've got to figure out who would be a responsible person that would chaperone.
Mom, or grandpa, the resident has been watching it. So
Where are we in relationships? I mean, yeah, this has got to be somebody who's going to be able to do chaperoning here in an objective fashion. Yeah, I mean, not overlook issues that might come about because she's still had 2 months to go on kind of retraining or composure, I guess, is what we're talking about.
Yes, sir.
I don't have a problem. But whatever is in the best interest of the child is foremost. Is that in the best interest? Parties seem to agree.
Yes, sir.
Then y'all know more about it. I'm looking at this probable cause affidavit. Probable cause affidavit is disturbing.
Yes, sir.
Because you disagree with what the investigators concluded. That's the problem right there. I mean, it's either going, we either need to have righteousness, that is honesty about it all in dealing with this, but you disagree with what the experts concluded. That's a problem. Because I've got to be able to trust your honesty in dealing with this. If you made a mistake one way or the other. Fix it and move on and be the best person you can be. I mean, you're not here alone on this planet. You've got a child that's dependent on you. Okay. So you've got to be a role model, an example subject, good example, not bad example. But first thing right out of the box is honesty. That's an issue that bothers me. That's not concluded. Now, that's a fact finder issue. If she wants to go to trial, but it's a dot that's not on the I. It's T that's not crossed. It's got to be resolved somehow so that we can move on. And because getting this straight and correct is part of fixing this mess here. And I mean, the grand jury indicted one way and she insists it's not that way. So that's going to be a fact finding issue before that's resolved. I'm not going to be granting some relief. But I think it's fixable is what I'm saying. I'm not. But we can't start out with a disagreement on the facts because we're talking about a child's best interest and your rights of under the law. But that's a big deal. What really happened and how do we, because until that can get really admitted to and resolved and concluded, how do you fix the problem? And I think it's fixable the way I'm reading it either way. It's fixable. It's got to get straightened though. A mistake was made according to the grand jury and you disagree with what the grand jury concluded and what the police say. And until that gets resolved somehow for everybody's satisfaction, the child you're not going to have, independence with the child. And I'm all for getting the unit back together. We got to do it correctly,
Is the state suggestion?
That's for y'all. Y'all are the parties on this. I'm just looking at it as the mediator here.
Yes, sir. I just want to make sure that it's in the order that the grandmother be present at all times.
That's just because it was a bond condition set by the court.
Yes, sir.
Okay. Your relief is as requested is granted.
That's all.
What's the next event?
Her completing.
She's got until December when?
December 28th is the my last class. And then they're gonna give me.
We set it till January and we can present her completion.
All right, first week in January. Thank you very much. Yes.
Make sure I get her name and address.
Yes.
The first one, Mr. Her daughter's name.
Mr. Constance, the doctor sent me an email and didn't want to infect us all. I appreciate
No,
it.
that's,
And
that's
Drug
okay.
America, the DA's office hasn't done the refile yet. So they're working on that, from what I understand. They're both in a quick recess.
Then we have, I had Diane Rubin.
All right, Barbara, thank you for the gifted membership. Thank you for the $5. The super chat, super sticker from Bailey, I believe. $5 there. Thank you very much. Really do appreciate it. My last day in all likelihood here, hosting for a while, filling in for Dan Soul, and he'll be back on Monday. We're hanging with Judge Stevens for a bit, and let's see what else is going on in Texas.
She was revoked her probation and they gave her 5 years. You gave her 5 years. And so we're trying to get her to accept the 5 years on one of the new cases relative she won't. It's just really. Bond says she's confident, but she won't take it.
You can't.
Well, you can't make it. I know. That's the issue I have.
But what's the competency status?
Honestly, held her competent, and then last year, we said she's competent, so exactly. It's not up to us, but I can't get her to say, I'll take.
Okay, well, that's okay.
So I guess she's sitting on the top.
It's her choice. I mean,
that's all.
Do we need to bring her in here so that you?
She's not here.
Do we need to bring her in here when we can go in here?
I don't think so. I mean, it's not.
So that you can talk to her and then we put something on the record and then let her have her statements made. I think that's what's important.
Yeah. And you know what I'm hearing?
So we can make a record of.
That's fine. Just find another day and bring her over here. We can do that. Yeah, maybe.
Because this, it looks like they were trying to dispose of it. And it seems like you think this might be a method that's in her best interest.
It is, because she's already got 5 years.
If she's competent, it's her choice, but let's put it on record so everybody later doesn't.
No, I'm good with that.
Well, I wanted to do that, but my lawyer wouldn't let me, you know?
Yeah.
Okay.
Because find time to bring her in.
Bring her maybe in the afternoon when you're here, John.
That's Miss Rubin.
Do you have anything?
Galen Hicks is on the desk. No, I gotta go get on. I gotta go put it together. On Galen Hicks.
That's some notion I'm trying to. Approval.
Where's Galen Hicks?
These are their study. I would need bodies over. We really
did.
Isn't Hicks, please? Thank you.
Mr. Laird's case.
The proposed orders.
Are you bringing me into this? I'm an investigator. I know.
What are you asking?
Dr. House will be an expert witness. I need to pay him.
Why'd you? Are you? Is he indigent?
Oh, he's indigent now. I mean,
Why did you choose? I've got Dr. Rapon, who was a licensed psychiatrist.
My mom just treated him.
So what? So what is that? You're asking for $5,000.
Right.
The taxpayers kind of are
We're going to have a fair trial.
You know, Dr. Rapon is a licensed psychiatrist.
Well,
I mean, he is the most renowned man.
It's not a competency issue.
It doesn't have to be. He's a licensed psychiatrist. What are you asking for? It's for mental health. He's a mental health expert.
It's asking for him to be evaluated, particularly for two reasons. One is potential mitigation evidence of punishment. The other is to assess the voluntariness of the statement / confession that he gave to the police and whether he was mentally capable of knowingly and voluntarily waiving.
But Dr. Rapon will be appointed to handle that.
As a defense expert?
He's an expert all the way around.
Well, I want an expert for the defense, not something that.
He's indigent, right?
Yes.
Okay. He is approved by the court as a fair and independent licensed psychiatrist, and he will make the choice.
But is he a defense expert or is he an independent?
He's going to give whatever answer that is accurate. This is a science. He'll give whatever is the answer that's accurate.
But I need a defense expert that I can consult with.
You can do that. That's what he does.
Information will be confidential and covered by attorney-client.
He will have to do that. He's not my psychiatrist. He doesn't work. He doesn't confide him to me, his decisions, or for everyone to know about. But he and I don't have a special relationship on this. He doesn't confide to me.
Well, the point
He
is-
is appointed, he is the psychiatrist that I appoint in indigent cases when it is necessary.
As a defense witness.
It doesn't matter what it is.
Well, my point is, I need somebody that I can
Well, when
rely on to have.
when a
have
defense
confidence
asks for
in
competency evaluation, I appoint, they are requesting it and I'm giving it to them.
This isn't a competency. I believe him to be competent. It's not a competence question. Somebody, I need a defense.
He's
independent
appointed,
expert.
he is the one appointed to help you on this. If you have a problem, you let me know.
Just to be clear, he's not to share information. This is a defense expert. He's not.
I believe he understands that. I don't think he shares information when he is hired and handles that. He's done this long enough to know.
Well, I understand.
No, I trust this man.
Normally, when he's appointed, it's an issue of competency or something that is, available.
Because I'm
Because
doing
we're doing it.
for
This
me,
is.
it's doing it, it's a request, but I am finding that that's the right thing to do. And then, so he kind of works for me to help me make my competency decision. This is not my decision to be made. I'm not going to be the arbitrator or the decision maker and the fact finder. You want a jury, I guess, to make it.
Well, it's just, as I said, Your Honor, it's a question, first of all, mitigation. And then secondly, as far as the issue of voluntariness of the statement itself.
Dr. Prapon testifies, not often, but has testified for both sides in cases that they hired him, not me.
Well, just for the record, I would request that we have Dr. Hamza, since he is familiar with the defendant. I've submitted a
I
report.
disagree. This is, he's indigent. He gets a competent man, and Dr. Ed Grapon, as you know, was leading psychiatrist here and was the man that was used in the James Byrd trials. And that was a worldwide. And he was the person who testified in those cases. And I find him to be fair, impartial, and most competent. That's what you're asking for. Plus, it's indigent, and this, you're asking for at least $5,000. We can get somebody as competent that does not cost the taxpayers unfair amounts.
Okay, well, just to be clear, so the motion to have Dr. Hamza.
Is denied. You will be allowed as indigent. I will appoint Dr. Ed Grapon, the leading psychiatrist in this area. I think, knowing him.
Should I
But we'll contact him and tell him that he's going to be appointed so that.
Well, I need to let him know the scope of the.
I understand you do. We're going to let him know so that you just don't come in off the street and he goes, what are you doing? And
I'm not here for a personal concept.
yeah, but we'll, in other words, set the table for you. Okay, so that.
And then as soon as,
They're off the
as
street.
soon as.
Have you ever worked with him before?
Yes,
Okay, well, he'll recognize you, right? Gosh darn.
But as soon as that's done, I'll be ready to try it. I know it's probably over 2 years, less than fairly long case.
Yeah. Who is the prosecutor on this?
I am.
Okay. He's, wife's working to move forward for trial.
Okay.
So we're gonna put it on the trial docket.
Yes, sir.
Okay.
Yep.
Okay.
Thank you. And let's let Dr. Rupert know about this case. And for Rice is going to, we're going to let him know.
Okay, I'll give him a call next week.
Hey, you're killing me on the lapel. There you go. Now you look great. Now you look.
Ma'am.
They're closed on Fridays, but it's almost all this, so they should never be nothing.
Okay. All right, what else? Is that it? Now it's Mr. Walker?
All right. First of all, Bailey, $4 super chat there. Thank you so much for that. Grandma TCF Mama Joan, $50. Thank you so much for your support. And Grandma TCF says she can't express words. She doesn't have words to express how much she wants to thank me. But the feeling is mutual. I thank you. I thank all of you for all of your support and hanging out with me here. TCF Live. It's Friday. It's become a super duper Friday, even under these kinds of circumstances. We wish Beth, Dan's wife, a speedy recovery. Yes, if you missed it in the pre-show, Dan was there in Utah. Beth broke her leg. That is Dan's wife. They're coming back. This isn't like Beth broke her leg, so Mike's now hosting for like 2 months. No, Dan will be back. All things being equal on Monday. So we're just here for the rest of today, but I really do appreciate your support. And we are trying to turn this into a super duper Friday here at TCF. All right. We have some other places we can go that we don't go to all that often. It is Friday, so sometimes courts, they get into landlord-tenant. Some courts don't even stream or aren't even online or in session on Fridays. So there's that to consider as well. So what we're going to do now is we're going to head over to, we'll stay in Texas, but we'll head all the way west.
Got it. Thank you so much.
And we will check in on the El Paso Magistrate Court.
Good morning, ma'am. What is your name?
And see what they're up to.
Brittany what?
Debus.
Debus. Okay, good morning, ma'am.
Good morning.
All right, Miss Debus is here on a theft of property, $3,000 bond, burglary of a building, possession of a controlled substance, evading arrest, and she also has a case out of the 210th. What is the date of the offense on that charge, Miss Calhoun, on the indicted case?
The 1 second, Judge. I'm so sorry.
Okay, no, I'm sorry. That's Judge Perez, so I do not have the authority to hear that case, so I can only hear the other ones. Risk assessment level is a 4. 2017 conviction for possession of drugs, coming in on all of these cases, and she says she has no money for bond. Mr. Loving?
Thank you, Your Honor. Ms. Debus, I'm going to ask you a few questions. Please only answer the questions that I ask. Do you have a phone number?
Yes.
What is it?
It's 915-433-9893.
And if you were released today, not that that's going to happen, but if you were, where would you live?
I would live with my baby's dad. He lives on 10438 Dunlap Drive, El Paso, Texas 79924.
Could you spell the name of the street, please?
DUNLAP.
And then, as the judge said, is it correct that you do not have any money to pay towards a bond?
I don't. Right now, no, I don't.
So like the judge said, there's a case out of the 210th. Your bond is set as at $100,000 in that case. Since you don't have any money, you're not going to be getting out today. We will be asking the judge to reduce your other bonds though, okay?
Okay, thank you.
Thank you, ma'am. No further questions, Your Honor.
Ms. Calhoun?
Thank you, Judge. From what I'm seeing, I just want to make sure we're on the same page. I think the theft, evading, and the state jail felony possession are the ones we are hearing today. The facts on that is the theft was Dollar General. Employees observed the defendant concealing items and leaving the location without paying for those items. The state jail felony possession charge is 0.79.
What is the date of the offense for that possession charge?
Yes, Your Honor. It is March 12th of 25.
March 12th. Okay, so it's not an SB9. Okay.
Correct. And then the evading, the misdemeanor evading is November 4th, where officers attempted to stop the defendant for an outstanding drug warrant. She fled on foot and was caught shortly after.
Can you remind me the burglary of building? What is the date of offense?
Yes, Your Honor. The burglary of a building, from what I'm seeing here, is February 18th of 25. That's the SB9, right?
No,
No.
no. It's after September 1st. It's an SB9 case.
That's right, that's right. Okay, it says oddly, but, 1 second, Judge. I just want to double check something here.
Okay, the burglary of a building is an SB9 case.
Yeah, that's what I saw on the docket, but the offense date, it is, I just wanted to double check that because it is February 18th.
No.
No,
For the burglary, it's November the 4th of this year.
okay.
Okay.
Um,
All right.
yeah,
All right. So on the theft of property, Ms. Debus was released on a peer bond. After she was released on a peer bond, she failed to appear in court. So I'm going to deny it based on prior noncompliance. On the burglary of a building, I'm not making any ruling because that's an SB9 case. On the possession charge, denied. On the evading arrest, denied. Prior noncompliance. Okay. And then the 2025 case that has been indicted, I'm not going to rule on that one. That is not, that's assigned to a district court, so I cannot do anything about that. Okay. All right, Ms. Davis, I'm not going to reduce your bonds. You're going to remain in custody until your lawyer goes and talks to you, and then y'all can decide what to do with all of these cases. You understand?
Yes, sir.
All right. Thank you, ma'am, and good luck to you.
Thank you.
What about over there?
Good morning. What is your name?
Good morning, Your Honor. My name is Tylen Alvarez.
Good morning, Ms. Alvarez. All right, Ms. Alvarez is here on a possession with intent to distribute a controlled substance in an amount greater than 4 grams but less than 200 grams. Risk assessment level puts her at a 4. She has a pending assault on a public servant, possession of drugs case indicted PG2, PG1, assault on a peace officer. That's a 4-count indictment. And then she has.
Those were dropped.
I'm sorry?
I said I thought they were dropped.
You thought they were dropped. Okay. Well, I don't know that they are. All right.
Okay.
And so she says she's not sure how much money she has for bond. Mr. Loving?
Your Honor, I see a note that says this is the same felony charge as the SB9 docket. So I believe this case might be on the SB9 docket.
Okay, give me a second.
Judge, I just checked and it was heard on the 5th.
Okay, ma'am, I'm going to cancel this hearing. This is an SB9 case. That is a case that allegedly was committed after September 1st of this year, for which I do not have the authority to modify the bond that was set by a district court judge. Okay? So thank you very much and have a good day.
You as well.
Okay, we have the interpreter here.
Good morning, Your Honor.
Gonzalez,
Good morning. How are you, Your Honor?
I'm doing well. How are you doing?
Doing very well, thank you.
All right, let me put this, start this. Spanish, start. Can you put?
Yes, Your Honor.
All right.
It's ready. Simpson? Thank you.
Buenos días.
Good morning, ma'am. What is your name?
Nancy Verónica Pereira Chávez.
All right, Miss Pereira is here on a criminal trespass $5,000 bond. Risk assessment level is a 2. She's coming in on discharge, no other priors. She has no money for bond. Mr. Loving?
Your Honor. Your Honor, my client has been a legal permanent resident since the year 2000. If released, she would live at 3503 Pershing with her parents. She's lived in El Paso for 13 years. I believe she's working on her GED, but needs to complete the math and Spanish portions. She is single with no children. She does have parents and siblings that live in El Paso. As you state, Your Honor, she does not have any money to pay towards a bond. She works cleaning houses. She does suffer from anxiety and depression and currently receives no mental health treatment. We would be requesting Takumi. She doesn't know her parents' phone number. And as far as the failure to appear, Your Honor, she states that she forgot about her court setting. We would be requesting another chance at a PR bond or any reduction that the court is willing to give.
Okay. I'm not going to give her a PR bond, Mr. Loving. She has been given a PR bond twice. The most recent one in September, and then she fails to appear in court in November. Ms. Calhoun?
Thank you, Judge. The offense date is 6/2/25. This is where officers arrived and met with the reporting party and informed that the defendant had broken into one of the apartments on the second floor, and this is an ongoing issue of trespass.
Okay. Ms. Pereira, I'm going to deny any bond reduction on your case based on your prior noncompliance with the conditions of your PR bond. Do you understand that? Thank you very much and have a good day.
All right, a couple of things real quick. First of all, if you missed it, Freya very briefly jumped up on my chair. Just wanted to say hi to everybody, apparently. And also, Grandma TCF, Mama Joan, throwing down another $20 super sticker. Thank you. Really, I can't express it enough. I really do appreciate it. While I fill in, of course, the super chats, super stickers do go to me. And you know, it's been a rough couple of years over here at Studio B, and it's kind of been one thing and another. You know, Beth had her situation, and we've had our own situation over here. We've been without hot water for like a week because our hot water heater broke, and it's a whole mess just to get it fixed, or not fixed. We're getting a brand new one. So there's that, and it's just one thing and another. So your support, let me tell you something. It really, really means a lot. And I'm working in the toy department. I just get to sit here and watch court and play different things for you guys. So, and that's to me, nothing could be more fun than that. All right, let's go back to Judge Elmore. Let's see what he's got going on up in Michigan. Looks like another contestant is coming on down. So, see what Judge Elmore's got cooking. And audio. Okay, thanks. Of course he would do that. I set this up so nice. I set this up so nice. And then the audio tab just goes out like that. And that makes me so grumpy. Not really that grumpy, but all right, there, we're going to fix it. Normally what I would do is I just switch on the main audio here and just play it that way. But I want to do it this way. Darn it. Gosh darn it to heck. There. Now, as I was saying before I was so rudely interrupted by technical glitches, here's Judge Elmore. Or not. Right. Well, this will work. I won't reboot. I'll restart the. We'll just do this. Here's how. All right. Okay. All right, don't you worry about a thing. Oh my gosh. All right, there we go. Judge Elmore, for realsies.
In the meantime, Mr. Carnes, why don't you go ahead and tell me the terms of that pretrial agreement, sir?
Your Honor, it's my understanding the defendant will plead no contest as charged. The reason for the no contest plea being potential civil liability.
That is my understanding as well, Your Honor.
All right, thank you very much. Thank you, Nancy. Ms. Bottoms, I'm told today that you're going to enter what's called a no contest plea today on the record. It's important that I tell you what the difference is between a no contest plea and a guilty plea. In a guilty plea, the defendant must state on the record what their actions were that caused them to be guilty of the offense. However, the court can take what's called a no contest plea. In a no contest plea, instead of requiring the defendant to recite a factual basis, the court is going to look at an exhibit that the parties will stipulate the court can look at. And then I will determine guilt based upon that. Now, a no contest plea can be given by a defendant instead of that guilty plea in a couple situations. One of them is when there is potential civil liability. Civil liability means that the other party or the alleged victim in this case could sue you. And then there are other steps. If they got a judgment against you, they can go against you, any assets, other things to try to recoup that money. In a criminal case, it works a little bit differently, but that's the difference between a no contest plea and a guilty plea. If you have any questions about that, ma'am, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Do you need me to repeat anything about that guilty plea, no contest plea that I just talked about? All right, thank you, ma'am. Well, today I'm told, I'm sorry, I know here in this file, you're charged on what's called a felony information. It's just a piece of paper, and it charges you with a single count. Now on that, it charges you with embezzlement by an agent or trustee. Embezzlement means somebody takes from somebody over whom they have either an employee relationship or a fiduciary or agent or trustee relationship, kind of like a business, a club, or so forth. So in this file, an embezzlement comes in different levels based upon the amount that's allegedly was taken. In this particular file, it's alleged that you took between a minimum of $20,000 or more, but less than $50,000, and that is a felony. Now that's a felony punishable by up to 10 years and or up to $15,000 or 3 times the amount that was embezzled. Now, there aren't any other allegations here involving any other nonprofits, is there, Mr. No. That's an important question for me to ask out loud, Ms. Bottoms, because there can be what's called consecutive sentencing if there are other convictions for similar conduct involving taking from a nonprofit. But I'm being told that there aren't any other allegations out there involving any other nonprofits. Consecutive sentencing is important to understand because sentences can either be run concurrent, which means at the same time. Let's say a person were convicted of 3 offenses at the same time, they would run concurrent, which means every day served is a day off of each sentence. Consecutive means that they can be stacked on top of each other. So let's say in a case like this, a person were convicted and the judge gave him 2 years, then they were convicted a second time, or they could get another 2 years, so they'd serve those. Consecutive means a total of 4 years. But in this instance, we're just looking at, well, there isn't any other charge, so it doesn't matter. So again, the charge is embezzlement by an agent or trustee. The allegation is that you're an agent or trustee of the Club Cadillac and that you took from them, at least 20,000 or more, but less than $50,000. And again, that's that felony punishable by up to 10 years and or $15,000 or 3 times the value of the property that was taken. I'm told today you're going to plead no contest to that offense as it's charged. Now, when you do so and you plead no contest, assuming I accept that plea and I find you guilty, you're going to be waiving certain rights that you would otherwise have at a trial, because you won't have a trial now. Anyways, I'm holding up a piece of paper that'll look that Mr. Harrison gave me in chambers, and it appears to have your signature at the bottom. Is that your signature?
Yes, sir.
Now, did you read through these rights before signing?
Yes, sir.
And did you understand those rights that were listed there?
I do, yes, sir.
Okay. And even more importantly, do you understand that if you plead no contest and then I end up accepting that plea, you'll be waiving these rights as they apply to this particular case?
Yes.
So you'll be given up the right to claim that the plea today was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to get you to enter this plea that no one's told me about today? Now, Mr. Harrison's probably talked about sentencing with you to give you an idea of what the exposure is. Even though I told you the maximum punishment is up to 10 years and so forth, he's probably talked to you about something called the Michigan Sentencing Guidelines. I wanted to tell you that those guidelines are not mandatory. The court must consider them, and there are some limitations on or requirements that the court must follow based upon how those guidelines are scored, but there is still some discretion within the court, which is me, when it comes to sentencing. So I highlight again, the guidelines are not mandatory, but they are a very important tool, and there are certain requirements that limit what I can and can't do for sentencing. But it's within the court's discretion. Do you understand? Now, if I accept this plea, we'll probably continue on bond here and have you come back in about a month or so, but we'll talk about that in just a moment. Before I ask you how you finally plead here, do you have any questions? All right. Now, again, I anticipate the plea to be no contest. I highlight that. I'm not trying to tell you what to say, but sometimes when I turn even in a no contest, people have seen it way too much on TV, they say guilty. So again, in this particular case, on that single charge, Ms. Bottoms, how do you plead?
No contest.
Thank you. Now, before we entered the courtroom, the court was given this exhibit by counsel. It's listed here now as or marked as People's Proposed Exhibit number 1. It is there's a couple different reports. I should call them an original and some supplemental reports. Just a second.
Well, he looks that up. Let me correct the record. Ashley with the $20 super chat. Thank you. Super sticker. Thank you very much. And Bailey with another $5 super chat. Thank you.
Report bearing the incident number of 71-3487-24. It consists of an original incident report that is 4 pages. Then it includes a supplement number 1 that consists of 3 pages, and it also consists of, supplement 2, not that I need it, but it includes supplement number 3. Supplement number 3 has 2 pages, and then behind it there are some other attached exhibits that appear to go along with that supplement. Mr. Carnes, are you asking the court to accept these exhibits totaled together as People's Exhibit 1?
Yes.
Mr. Harrison, any objection?
None whatsoever, Your Honor.
All right, thank you. People's Proposed Exhibit number 1 is hereby admitted as I described a moment ago on the record. Again, as I've already stated, the court did go through this thoroughly before taking the bench today. I'm going to highlight the report described an incident with a date range between possibly March 1st of 2024 through potentially October 16th of 2024. Looks like the report was actually made the day before on October 15th of 2024. I'll note that it covers the venue of Club Cadillac, which the court notes, even according to the report, is a 501c3 connected to Northern Lakes Community Mental Health, and that it's located here in part of the city of Cadillac out there in Herring Township here in Wexford County. I will also note that it describes here that Ms. Bottoms was not only a member of that program, but then later became a treasurer for the program. I'll note that it appears here that the suspicions rose back in July and September of 2024. An investigation or internal investigation was conducted. I'll note that inside the supplement number 1, it describes the state of the investigation. Like the events allegedly, did begin in March of 2024. I see the amount that's listed on page 2 of 3 in supplement 1 actually adds, if added together and we're all totaled, would be approximately $73,970.59. Even more importantly, I'll also note that on page 3 of that supplement number 1, there are statements that the court does now consider a confession. Therefore, oh, by the way, and I've also looked at the portions that were in supplement number 3. Mr. Carnes, do you believe the interest of justice do not require a defendant to state a factual basis based upon potential civil liability?
Yes, Your Honor.
Do you believe that this report contains adequate information and evidence to support the plea?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court is in compliance with Ms. Scroll 6.302?
Yes, Your Honor.
Mr. Harrison, do you agree with all of those statements?
I do, sir.
Great, thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information contained inside the exhibit, People's Exhibit number 1, which again was admitted by this court into evidence, satisfies the elements of the charged offense. The court also finds that the interests of justice, as stated earlier on the record, do not require the defendant to recite a factual basis. Therefore, the no contest plea is accepted. The defendant is found guilty of count 1. Ms. Bottoms, this case will now be set for sentencing. That sentencing will occur in about 4, maybe 5 weeks. We do them every Monday morning. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. Now, that report will describe the offense, describe the pretrial agreement, give me information about you, maybe include any prior criminal history if there is any. It will also include a score to the guidelines, which I've already told you were not mandatory, and it will make a recommendation as a sentence. Please keep in mind it is only a recommendation. I'm quite sure if you ask all of them downstairs in that office or everyone else here in this courtroom, it is merely a recommendation, as I'm very independent and I will make my own decision. All right. Now, when we come back for sentencing, you'll probably hear maybe some from victim statements. I just want you to be prepared for that. Between now and then, this report is going to be prepared. There are 3 steps that involve you. When you leave this courtroom, you're going to go downstairs to the Michigan Department of Corrections office. They're also known as the probation and parole office. Now, if you take the elevator all the way down, or take the steps, stand at the same spot, you'll do a button hook to the right, go down a little ramp where you see a bunch of soldiers in black and white fighting over World War I. Probably one of the battles of the Marne, but anyways, won't go into history. You walk down past that sign, go through the door at the end of the hallway, second door on the left is their office. They're gonna give you a packet. You're gonna open it up, follow the instructions, complete all the information that's asked on it. Turn it in. They'll also schedule an interview with you, and you have the right to have Mr. Harrison present during the time of that interview. And number 3, Mr. Harrison is gonna have to meet with you prior to coming back to court, because he's gotta go over that report with you, because you each have to make sure it's complete and accurate before the court gives assumptions on it. Do you understand? You have any questions about what we have done today? You have any questions about what you got to do when you leave the courtroom today? And we should be back in about 4 or 5 weeks. Mr. Carnes has got a curious look on his face. Is there anything else over there?
I'm looking at a different file.
He's not even paying attention to me. I hereby hold no, never mind. No contempt today. Anything further from you today, Mr. Harrison?
Nothing further, Your Honor.
Ms. Bottoms, we'll see you in a couple weeks. Anything from you? Thank you. Your bond continues. We remain, I'm sorry, we are adjourned. Thank you.
All right, TCF Live. It's Friday. It's fun. We're having a good time here on Friday. That's Judge Elmore. We might check back in with him in just a little bit. I'm going to show you something. I just want to show you this. We're not going to go here right now, but this is Judge Simpson's court currently. All right. This is Hollywood Squares. It's landlord tenant. I had been monitoring to see if anything got absolutely nuts and blew up and went crazy. Maybe we'll just check in with it for a few minutes later on and just kind of peek in, because Judge Simpson's always interesting. We love Judge Simpson here, but I just thought I would show you that he is in session. There's a lot going on over there, but we'll see what happens with all that in a little bit. We'll check back in with Judge in a little while. In the meantime, let's head back to El Paso, and we'll go to a little bit more of the jail court, the magistrate court over here in El Paso.
Good morning. All right, Mr. Bustamante is being accused of aggravated assault with a deadly weapon. Risk assessment level is a 2. He's got a juvenile record that dates back to 2014 and 2015. Nothing then. Nothing since then. He says he has no money for bond. Mr. Loving?
Yes, Your Honor. Mr. Bustamante is a United States citizen. He doesn't currently have a phone number. He lives at 1116 North Oregon, apartment 33. He's been there for a month and has lived in El Paso his entire life. He got up to the 11th grade at Parkland High School. He is single with no children. In El Paso, he does have grandparents, an uncle, and a cousin. He does not have any money to post towards a bond. He is unemployed, although he does have a job at Speaking Rock waiting for him. He did suffer a traumatic brain injury and therefore has both short-term and long-term memory loss. He also suffers from seizures. He receives food stamps. He is a member of the Tigua tribe, Your Honor. He does have a social worker. He stated he would bring her phone number or their phone number to court with him if necessary, and he does deny these allegations, Your Honor. We would be requesting any reduction that the court is able and willing to give. Thank you, Judge.
Okay, and I misspoke. He does have an arrest in 2019 for assault family violence and in 2023 for assaulting a pregnant person. Ms. Calhoun?
Thank you, Judge. This is an incident where there was a witness that saw what was happening. He saw the defendant holding a 12-inch hunting knife to the victim's throat as he was driving by, and he honked and yelled, causing the defendant to release the victim and walk away. And yeah.
What is the name of the complainant?
The victim's name is Destiny Ibarra.
Okay. And the relationship?
Is they are dating.
Okay. All right, sir, I'm going to deny any bond reduction based on the nature and circumstances of the alleged offense and for the future safety of this community and of the alleged victim. Do you understand that, Mr. Bustamante?
Sir, may I say something?
One of the rights that you have, Mr. Bustamante, is the right not to make any statements, and any statements that you do make could be used against you in court. Now, we have a court reporter present. She will be taking down everything that I say and everything that you say, and those statements could be used against you in court later on. So my suggestion to you is don't say anything. Talk to your lawyer. Somebody from the public defender's office is going to go talk to you, and you can tell that lawyer in private everything that you want to tell me here today, and then that lawyer can tell you whether that statement will help you or hurt you in court. Do you understand? Do you still want to make a statement?
Yes.
Mr. Loving, would you like to advise the client, please?
We discussed this case earlier. My client, I'm gonna say something and then I think that might cover what he wants, Judge. We'll talk to him in just a second. But my client does deny knowing this person. He also denies assaulting this person. The facts I would state as stated in the affidavit are not as clear as the prosecutor has made it. My client would contend that he simply drew a knife to protect himself against a third party, not the complaining witness, the alleged witness. And so again, he disagrees with all these facts. I know, Your Honor, that doesn't necessarily change your opinion about your ruling, but I believe that's what my client would like to discuss. Is that correct, sir?
Yes.
So we'll talk to him about that, Judge, and we'll discuss his defenses.
All right. Thank you, sir. Good luck to you.
That's it, sir. Arieta? Can you switch with him?
Good morning, sir. What is your name?
Eduardo Junior Arrieta.
Mr. Arrieta is here in a possession of a vape pen, I believe. Risk assessment level has him at a 4. He's got failure to appear. Ms. Calhoun, is it a vape pen?
Yes, Your Honor, it is a THC vape pen.
Okay, are you opposed to releasing Mr. Arrieta on a peer bond?
I'm going to defer to whatever you'd like.
All right, Mr. Arrieta, you're going to be released today on a personal recognizance bond.
Thank you, Your Honor.
Under administrative conditions. Do not commit any other crimes and stay in contact with the peer bond office. Do you understand?
Yes, Your Honor. I appreciate you, all of you.
Well, before you go, I want to tell you something.
Yes,
Now that you're being released on a personal recognizance bond on a felony case, if you are arrested for another felony offense, then I'm not the person that's going to set your bond. It's going to be set by a district court judge, and I doubt very much that you're going to get a peer bond. So, all right, please understand that. Thank you, and have a good day.
Thank you. Have a good Thank you. Have a good day.
All right, who's next?
Your Honor, that's it for this floor, but on the next one, I'm gonna have 9 defendants.
Okay, now before you go,
Yes.
there is an SB9 case that I've identified. His name is Wesley Lumsey.
Okay.
Okay, we don't need to hear Mr. Lumsey.
Okay, perfect. That was to the floor I was going. Okay, Your Honor.
Thank you. We'll be in recess.
All right. That is El Paso Magistrate Court. Always good to check in a couple of different places. We started the day out in kind of a different place. You know what? Let's go back there just for a minute. Let's go back to Judge Molly Hennessy Greenwald and see what's going on over here, because we that's where we started. We'll just kind of go back here. It's a quiet day in the courts, so we'll see what we got happening here.
And hello, good morning, Mr. Basiga.
Morning, Your Honor.
Good morning. And Mr. Beard, good morning to you. If you would please unmute.
Good morning.
Good morning. I'm calling the matter of the City of East Lansing versus Brett Ashton Beard. This is case number 25953OM. Here today for an arraignment. May I have appearances, please, for the record?
Yes, good morning, Your Honor. Brendan Basiga, on behalf of Mr. Brett Beard, I'm appearing by Zoom, so is my client.
Thank you so much. Mr. Beard, can you please confirm that you can hear and see me and Mr. Basiga?
Yes, I can hear and see both of you.
Thank you. I can hear and see you. This is an arraignment. The purpose of our hearing is for me to inform you of the charge against you, the maximum possible penalties, and all of your rights. You're charged in this misdemeanor complaint in count 1 with the crime of being a disorderly person by fighting in public. That's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Do you understand the charge and the possible penalty?
Yes.
You have a right to an attorney to assist you. If you can't afford an attorney, one will be provided for you at public expense. Mr. Basiga is here representing you today, and he has filed an appearance in this matter. You also have a right to a trial where you would have many rights available to you. Mr. Basiga, have you reviewed the trial rights with your client?
I have, Your Honor.
And how would you like to proceed today?
Thank you, Your Honor. We'd ask that a not guilty plea be entered on behalf of my client, as well as a pretrial conference be set in this matter.
Very good. We will do that. And our pretrial conference date is December 11th at 9:15 a.m. Mr. Beard, I have an address for you in Eagle, Michigan. Is that a good address?
Yeah.
Okay, that's the address the court will continue to use. You need to make sure that you monitor your mail there and update the court immediately if that address changes. Mr. Basiga, on bond.
Thank you, Your Honor. I can tell you, Your Honor, Mr. Beard is obviously taking this very seriously. I think within 5 hours of actually receiving the mail with the summons, he immediately contacted our office. I think within 24 hours of that, he retained us. Mr. Beard has absolutely no prior criminal history. And what I mean by that, Your Honor, I mean, nothing has ever been expunged, no 7411, no HYTA, absolutely nothing. If ever there was a candidate for a PR bond, Mr. Beard is actually it. I have had zero problems communicating with him. He is definitely taking this very seriously. He lives in the county. He has direct ties here. I do not anticipate any problems whatsoever with Mr. Beard. It was a pleasure meeting with him and his mother. I anticipate that we can find a resolution to this in short order.
Okay, thank you very much. Mr. Beard, did you hear everything Mr. Basiga just told me?
Yes.
And is that all true and accurate?
Yes.
That helps me make my bond decision today. And I do agree a personal bond is wholly appropriate here. And that is because I have good reason to believe that you will always come back for your court dates based on everything Mr. Basiga said in terms of how serious you are taking this case, and also your appearance here today for your first court hearing, timely and attentively, respectfully. I also believe that given your lack of criminal history, the allegations here, and again, everything that I've been told about you, that there are any public safety concern could be addressed through bond conditions. So your bond is $500 personal recognizance. That means you do not have to post any bail. I'm releasing you once again because I trust you're going to come back to court and comply with my conditions. And they are as follows. You must appear as directed. You may not leave the state of Michigan without permission of the court. You must not commit any crime while you are on bond to this court. You must not specifically engage in any assaultive, harassing, or threatening or intimidating behavior towards any person. And you may not have any contact with an individual named Benjamin Bruce Trevorrow. I don't know the relationship, if any, between you and that person, but in any event, that is an important condition. Violation of that condition would subject you to immediate arrest without a warrant. Is that clear?
Yes.
Okay. Mr. Basiga, anything further from you?
Nothing further. Thank you very much, Your Honor.
Okay, very good. That's all for this case. Good luck, Mr. Beard.
Thank you very much. Thank you, Your Honor.
Well, all right. I guess that's that. Let's see here. Well, I'll tell you what. We said we'd do it. Let's do it. It's landlord-tenant, but you know what? It's Judge Simpson's landlord-tenant, so we all know things can get kind of interesting over there. So let's see what's happening with Judge Simpson.
I'm
here.
going to adjourn this out November 14th 2025 at
Your
3
Honor,
p.m.
is there any possible way you could do it the following week? I'm going to be out of town that week. I've been working with Miss Ferrulo for 2 years. I'd really like to be there for her.
Your Honor, we would be agreeable to 2 weeks.
Thank you. All right.
law service.
Thank you so much.
And even if they weren't, I was going to do it anyway, but
Thank
I was just going to let them answer.
Okay.
Anyway, all right. So that's going to be the 21st.
Okay.
All right. So I'm going to adjourn it to November 21st, 2025. That will be at noon.
Thank you so
All
much.
right. In person. All right.
Okay.
Okay. You take care. Have a great weekend.
You too.
Arbor Woods versus Elisa Franklin.
Casey Matson for the plaintiff.
Elisa Franklin, not here. You may proceed.
Thank you, Your Honor. We do request entry of a default possession only judgment. Rent to retain is
I'm
$5,000.
here.
Oh,
Oh, hold on. What's your name, ma'am?
Lisa Franklin.
Okay, so she's here. You got her.
Uh-huh.
Okay, do you have a camera, ma'am? You'll need to turn that on.
Okay.
right. What is
Hold on.
plaintiff's claim?
Your Honor, we have rent to retain of $5,562.30. Cost of $186 for a total of $5,748.30.
All right. And Miss Franklin,
Yes, I'm trying to-
how are you intending on getting that paid?
On the 17th, that's how, we'll just pay the difference and stuff. So.
I'm
if you want to
sorry?
take- Can you hear me?
I can hear you.
Okay. So the 17th is when, get paid and then we'll be able to pay, what's owed.
Okay, so you think it can be paid in full by the 17th?
Yes.
Okay, so here's what I'm gonna do.
Okay.
I can't adjourn it out past the 14th right now. So I'm gonna go, I'm going to adjourn it to the 14th, 2025 at 3 p.m. That's an in-person hearing. So you'll have to come down to the courthouse. What I would suggest, if you got proof that that payment's coming in, that you contact the attorney's office or your landlord to see what you can work out, okay?
Oh, okay. Thank you.
Thank you. We'll see you on the 14th.
Okay.
Arbor Woods versus Melinda Harrison.
Casey Matson for the plaintiff.
Melinda Harrison, they are not present. You may proceed.
Your Honor, this is actually a dismissal without prejudice.
All right. That case is dismissed. That's without prejudice. Arbor Woods versus Marcus Hollis.
Casey Matson. Oh,
All right, Mr. Hollis, I'll need a camera, but while we're doing that, what is plaintiff's claim?
Your Honor, rent to retain is $3,500.31. Court cost of $186 for a total of $3,686.31.
All right, I don't have a sticker on this. Okay, sir, how are you intending on getting that paid? Mr. Hollis, I can't hear you.
Just need a couple weeks to pay it.
Are you good? What do you mean a couple weeks to pay it?
I'm gonna pay. Well, I got a month behind because I moved in on the 28th and they charged me a full month rent.
Okay, I'm not sure on that, but so.
But I could pay a whole month
When
by
are you,
Friday.
when are you intending on paying this, sir?
2 weeks.
Well, I can't give you 2 weeks, so you're gonna have to come up with a plan that's gonna be approved by the landlord. So you're gonna either have to call the attorney's office or call your landlord and try to work something out. Next time, if you appear via Zoom, you gotta have a camera that I just told you to turn on. So I'm adjourning this out to November 14th, 2025 at at 3 p.m. That's an in-person hearing, so you got to come down to the courthouse. Thank
Okay.
you.
Thank you.
Arborwoods versus Latanya Ingram.
Casey Matson for the plaintiff.
Ingram, they are not here. You may proceed.
Thank you, Your Honor. We request entry of a default possession only judgment. Rent to retain is $3,670.80. Cost of $186 for a total of $3,856.80. That would be a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Arborwood
All right.
versus Ashley Irwin.
Oops, that's not what I wanted to do there. It's Friday. It's TCF Live. And, you know, coming up in a little while, we might just have to head over to Dungeon Court. That's a little preview of things to come. But since we do like to do some different things here on TCF from time to time, and I know Dan's gone here before, but we're going to do it now. Let's head over to the 17th district of in Colorado. This
can be made
now
for you to be able
this
to
is I don't know who this is. This is just the
Puede que
17th
haya
District Court of Colorado.
para hacer los arreglos
And
necesarios
let's see
para
what they've
poder
got going on.
hacer la logística para pasar tiempo con el hijo.
Because again, unless and until the protection order as to Ms. Ortiz is modified, there is zero contact with her.
Hasta que se modifique la orden de protección que tiene con la señora Ortiz, no puede tener ningún contacto con ella para nada.
All right, Ms. Herrera, regarding bond.
¿Y con respecto a la fianza?
I'm asking the court for a personal recognizance bond or a bond below schedule in this case.
Estoy pidiendo una fianza bajo palabra o por lo menos una fianza menos de lo programado para ese tipo de caso.
I would first note the CPAT score of 8, risk category 1.
Entonces quiero indicar que tiene una categoría según la evaluación CPAT, es categoría A, subcategoría 1.
I know the facts stated in the are probably concerning to the court.
Yo sé que los hechos que están en la acusación deben preocuparse de usted, señor juez.
I think there, with the protection order, if the court were to impose any additional conditions of bond, that could alleviate any community or victim safety concerns.
Señor juez, yo creo que con las condiciones de la fianza usted puede remediar lo que son preocupaciones de seguridad de la comunidad o la víctima.
Mr. Mellado doesn't have any criminal history. This is his first time in custody.
El señor Mellado no tiene antecedentes penales, es la primera vez que ha estado detenido.
So we're asking the court to give him an opportunity to show his willingness to comply with court orders.
Entonces estamos pidiendo que usted le permite la posibilidad de demostrar que está dispuesto de cumplir sus órdenes judiciales.
There's nothing to indicate that he won't return for his court dates or comply with the protection order.
No tenemos nada que indique que él no esté dispuesto de volver para sus audiencias y cumplir con sus órdenes, señor juez.
Thank you. Mr. Basilio.
Señor Basilio?
So the people are concerned about the allegations in this case, including the allegation of strangulation.
Entonces la fiscalía está preocupada en este caso por las acusaciones, incluyendo la acusación de que hubo estrangulación.
The affidavit indicates that caused the victim to be unable to breathe or speak.
Es que según la acusación, eso indicó que la víctima, a causa de eso, no pudo ni hablar ni respirar.
That's in addition to the strikes to the head, and all of that was in the presence of a child.
Eso es además de los golpes a la cabeza y todo eso pasó en presencia de un niño.
And all of this seemed to be over $10.
Y todo eso pasó por un lío sobre $10.
Based on those victim safety concerns, the people don't believe that a PR bond would be appropriate here.
En ese caso, no creo que una fianza bajo palabra es apropiado en este caso.
Thank you. While I do see that CPAT score of 1 and no criminal history,
Aunque sí veo que es una categoría CPAT 1 y que no tiene antecedentes penales,
the allegations here are aggravated.
son acusaciones con agravantes.
I'm going to set bond at $2,500 cash surety, which is a significant reduction.
Entonces voy a aplicar una fianza de $2,500 en efectivo o con fiador, que es una gran reducción.
Next court date is November 12th at 1:30 p.m. Division R2 for return filing of charges.
Listo, su siguiente audiencia va a ser para el día de noviembre, 1:30 de la tarde en la sala R2 para volver a presentar cargos formales.
All right, good luck, sir.
Muy buena suerte, señor.
Wahoo, thank you for the $10 super chats. Really do appreciate that.
Listo, ¿usted tiene armas de fuego o municiones?
Ask him to check the box on 22.
Entonces marca esas cajas que estoy enseñando aquí.
Ok. Aquí. Vamos a ver. Ah, pero pongo un no.
¿Cómo dijo?
Ask him to print and sign his name on the back.
Aquí atrás, eso es para poner su nombre en letra molde primero y luego su firma.
Un nombre.
Again, we're in the 17th District Court of Colorado. What is that, Martelon? And we're here for a few more minutes. And we can go a couple places, and then eventually we're gonna sacrifice a goat, call upon the evil spirits, and head to dungeon court.
Necesita su nombre en letra molde y luego la firma.
This is the second protection order issued by the court. Please ask him to sign his name, please.
Es la segunda orden de protección, igual a nombre, letra molde y luego la firma.
Yeah. Okay, these are his copies. See the deputies in the back of the courtroom.
Esas son sus copias para pasarle con los funcionarios ahí detrás.
All right, before we proceed with our remainder of our Spanish language matters, Ms. McCarthy, can you hear me? Welcome.
I can, Your Honor. Thank you. Good morning.
I appreciate you appearing. Have you had a chance to speak with Mr. Fernandez yet, or do we need to create a breakout session for you?
If we could create a breakout session, that would be great.
Okay, we will go ahead and make you a co-host unless you already. Can you do that? We're just going to double check.
All right.
Okay. Which one?
Fernandez.
Fernandez.
Yep, and then he is going to be speaking with
Let's do a breakout.
ADC, Ms. McCarthy. All righty. Thank you very much. And then as soon as y'all are done, I should be done with the Spanish language matters, and I'll address your matter so I can get you going, Ms. McCarthy.
Great. And will he be coming under the advisals screen?
I believe so.
Okay. Thank you.
Sounds good. Thank you.
I can next call the Carrero Villalobos matter.
Okay, Mr. Curro Villalobos, come on up.
Listo, señor Carrero Villalobos, adelante, por favor.
Good morning, sir. This is 25 CR 3090.
Listo, llamando caso 25 CR 3090.
Can I have appearances?
¿Te pueden presentar, por favor?
Benjamin Basilio for the people.
Hizo Benjamin Basilio por parte de la Fiscalía.
Paige Hare for Mr. Carrero Villalobos.
Y soy Paige Hare para el señor Carrera Villalobos.
Sir, before we address your new case, I'll advise you you're also being held on a Jefferson County case.
Entonces, señor, en su nuevo caso, tengo que decirle que está detenido aquí para otro caso que tiene pendiente en Jefferson.
That case is 25 CR 1702, and your bond was set at $1,500 cash or surety.
En ese caso es el número 25 CR 1702 y ese caso tiene una fianza con fiador o en efectivo de $1,500.
In your new Adams County case, I'll begin by issuing a protection order.
En su nuevo caso que tiene en el condado Adams, voy a empezar con una orden de protección.
The alleged victim is John Arias, date of birth 5/29/89.
Entonces la víctima supuesta en este caso, persona protegida, es John Arias, tiene fecha de nacimiento del 29 de mayo del 89.
This is not governed by Brady, but is governed by the Victims' Rights Act.
Eso no está regido por la ley Brady, pero sí por la ley de derechos de víctimas.
Due to the nature of the allegations, I will activate provisions 1 through 7.
Basado en las acusaciones, voy a aplicar lo que son las condiciones 1 a 7.
Meaning, as it relates to Mr. Arias, you shall not harass, molest, or retaliate against him.
Eso quiere decir que con respecto al señor Arias, usted no puede acosar, molestar ni tomar represalias en contra de él.
You shall stay away from his home and any location where he may be found.
Tiene que alejarse de la casa de él y cualquier lugar donde es probable encontrarlo.
You may not contact him directly or indirectly.
Usted no puede contactarse con él directamente ni indirectamente.
You shall not possess, purchase, or control firearms, other weapons, or ammunition.
Entonces no puede ser en posesión de, controlar ni comprar armas de fuego, armas o otras municiones.
And you shall relinquish any such objects within 24 hours of release.
Y tendrá que entregar a las autoridades ese tipo de artículos si lo tenga a la policía de entre 24 horas después de salir en libertad.
Shall complete an affidavit and file it with proof of relinquishment within 7 business days.
Y tendrá que llenar lo que es una declaración juramentada y comprobante de entrega a las autoridades dentro de 7 días después de salir en libertad.
You may not possess or consume any alcoholic beverages or controlled substances.
No puede poseer, comprar ni consumir bebidas alcohólicas ni sustancias controladas.
Conditions of this protection order will be conditions of your bond.
Entonces, las condiciones de esta orden de protección también son condiciones de la fianza en su caso.
If you violate any of these conditions, you could be subject to additional criminal or contempt sanctions.
Si usted incumple esas condiciones, puede estar sujeto a desacato a la justicia o otros cargos penales.
And you'll need to sign a copy of this as soon as we're finished speaking.
Y tendrá que firmar copia constatando todo eso tan pronto que dejamos hablar.
Ms. Harrer, regarding bonds.
Señor Hare, con respecto a la fianza.
I'm asking the court to consider setting bond below schedule in this case.
En este caso estoy pidiendo que usted, por favor, pueda aplicar que sea menos de lo programado para ese tipo de caso.
He does obviously have that Jefferson County hold.
Obviamente, todavía está detenido según para el caso de Jefferson también.
The court may be able to see Mr. Carrero Villalobos is in a sling.
Quizás se puede ver que él tiene un soporte en el brazo.
It sounds like he was injured while he was being arrested and he's in pain from that injury.
Parece que salió lesionado del momento cuando lo estaban arrestando y siente dolor por esa lesión que sufrió.
He has ties to the area.
Tiene lazos en la comunidad.
He's working in car repair. He's been doing that for about the last 2 years.
Está trabajando, reparando carros y lleva más o menos 2 años haciendo eso.
He has stable housing where he lives with his 4-year-old son and his wife.
Tiene una vivienda estable donde vive con su hijo de 4 años y la esposa.
So we're asking the court to consider all of that and set bond below the suggested amount.
Entonces estamos pidiendo que se tome todo eso en consideración y poner una fianza que sea menos de lo programado para ese tipo de caso.
Thank you, Mr. Basilio.
Listo, señor Basilio.
So the people would ask for the court to keep bond at schedule.
Señor juez, estamos pidiendo a la fiscalía que usted sigue según lo programado para ese tipo de caso.
In combination with the failure to appear in the Jeffco matter, the defendant also ran from police in this case.
Aparte de faltar con presencia en el caso de Jeffco, él también huyó de la policía en este caso.
He then initially lied about his name.
Él inicialmente mintió sobre su nombre.
All of that suggests that he will not appear for court in the future and will not abide by court orders.
Todo eso sugiere que no va a asistir a sus audiencias en el futuro y que no va a cumplir sus órdenes judiciales.
And the people also have community safety concerns given the allegations of not just one weapon, but 2 involved here.
Y también tenemos preocupaciones respecto a la seguridad de la comunidad debido a la involucración de no solamente un arma, sino 2 armas en este caso.
So based on that, we would be objecting to a lowered bond.
Basado en eso, estamos en contra de la reducción en la fianza.
The court is also concerned about the community safety issues.
También tengo las mismas preocupaciones de seguridad de la comunidad.
I'm concerned about the lack of time between the Jefferson County case and this one.
También me preocupa el poco tiempo entre los 2 casos, el de Jeffco y este.
He was also given a low bond in that case, but has a number of points where he has been violative of his pretrial supervision in that matter.
Es que él sí tiene una fianza bajo en este caso, pero ha incumplido la supervisión varias veces en este caso.
And due to the aggravated allegations compounded in this case, I do believe a $20,000 cash surety bond is appropriate.
Entonces, debido a todo eso, junto con la seguridad de la comunidad, me parece apropiado a una fianza en efectivo confiador de $20,000.
Next court date is November 12th, 1:30 p.m., Division R2 for return filing of charges.
Listo. Entonces, su siguiente audiencia va a ser para el día 12 de noviembre, 1:30 de la tarde, en la sala R2 para cargos formales.
Good luck.
Muy buena suerte, señor.
All right, Mr.
All
Interpreter,
right.
you-
That
defendant, does
is
he own
the
weapons, firearms, and ammo?
17th District
Pregunta usted
Court
si usted tiene armas de fuego
in
o otros tipos de armas
Colorado.
y
I
municiones.
can't seem to mute it. There we go. The 17th District Court in Colorado. And good to check in and see what they are doing over there. If we look over on some of the other courts that we have going on, of course, Judge Simpson, he is still doing landlord-tenant. It's Friday after all, so that's what he's got going on. Let's see. We've got, like I said, it's Friday. It's kind of a quiet day in the court systems. So why don't we... Let's see. We need a few minutes before we can go to dungeon court. So let's say hello to Judge Boyd and see what she's got going on over here.
ICR 012142, State versus Christy Ramirez. Can I have parties announced for the record?
Lauren Espinoza for the state. Valentina Coburn on behalf of Christy Ramirez.
And are you Christy Ramirez?
Yes, ma'am.
Counsel, you received all discovery. Did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Ms. Ramirez, did you review the true bill of indictment with your attorney? Did you understand it and sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Ramirez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
You're charged with theft of property, less than $2,500 with 2 or more previous convictions. The state jail felony range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses? Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is unsure.
Ms. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Absolutely.
By entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's 100 days in the Bexar County Jail under 1244. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes, ma'am.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
State, you may be excused. Thank you. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports?
Yes,
But
ma'am.
most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing? Anything you wish to say on behalf of your client?
We're asking the court to follow the plea bargaining agreement.
All right. The court will follow your agreement, sentence you to 180 days in the Bexar County Jail on a 1244. There's an $800 fine, time, and money to run concurrent. The court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And I'm sorry, also as a part of her sentence, there's to be no contact with Walmart. All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, off the record. How old are you?
53.
When are you going to stop stealing?
I am proactively in classes for substance use, and I feel like I'm at the end of my rope, so I'm ready.
All right, so here's the thing. If you continue to steal, one, you're going to continue to get caught and you're going to end up in jail. And at some point, these are going to be enhanced to 2 to 20 with the range of punishment, and you're going to be looking at 20 years for stealing.
Yes.
So if you continue the way you're going, half of your life is, well, you're already at the halfway point. I can say that. Unless people are planning on living to be 100, over 100, you know, I mean, it's doable. But if you want to be in good health, you know, nobody's living to be 200. I don't know anybody who wants to really live to be 200, but I'm in the twilight of my life, right? So you're going to wake up and half your life is already going to be gone because of what you're doing. So if you have a drug or alcohol problem, there are plenty of places in San Antonio that will help you. Going to Walmart, going to these other stores and stealing and thinking you're not going to get caught, not going to happen.
Right.
At Walmart now, at least I think at some of the Walmarts, they film you as you're coming in. They have gates, right? Everything is on lockdown because people won't stop stealing.
Understood.
All right, good luck to you.
Thank you, Ms. Quinn.
You're welcome.
Judge, if I may, did the court say 100 days or 180 days?
100 days.
Yes.
Sure.
What is the date for me?
100.
Oh.
I'm going to stop mumbling today. Okay.
TCF Live, it's Friday. Hanging with Judge Boyd for a little bit because it's our commitment here. My personal commitment to make sure that you get 9 to 11% more Judge Boyd. That is something that I have promised to do. It's contractually obligated that when I'm filling in for Dan, you're going to get Judge Boyd. That's just how it works. That's an interesting case. Lots of theft convictions. And I mean, when you're 50 years old, man, you got to stop stealing at some point. And Walmart. Now, I don't know how much of a punishment that is to ban someone from Walmart. I mean, to me, maybe I should write to Judge Boyd. Hey, can you give me an order not to go to Walmart? I'd love not to go. Please. Please. All right. We are going to continue here with Judge Boyd for a little bit. We're in the way back here, so we're going to get you another case here, and then we'll maybe we'll head to dungeon court.
Are there any applications?
No, Judge.
And are you Mr. Reed?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Mr. Reed, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading? Oh, counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state would move to waive the enhancement allegation and proceed just on the underlying charge of less than a gram.
No objection.
All right, Mr. Reed, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct.
Mr. Reed, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed to 121 days in the Bexar County Jail under 1244. There's an $800 fine. There is taken in consideration 2025 AL 008841. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead?
No contest.
State any evidence.
Yes, Your Honor, state offers states Exhibit 1 and all attachments, and I also have that rejection form as well.
State, you may be excused.
Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments and review the same. After reviewing states Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court to follow the negotiated plea bargain agreement. My client did acknowledge that he made some bonehead questionable decisions. He was dealing with some homelessness at the time and was maybe looking to get some pillows and things like that to sleep on. However, putting himself at risk for arrest, being in someone's yard. He's deeply sorry about what occurred and willing to learn from it and does not want to return to this courtroom. He says it's a little bit chilly in here, so he does not want to go through that again, Judge, for all those reasons.
All right. The court will sentence you to 121 days in the Bexar County Jail under 1244. There's an $800 fine, time and money to run concurrently. Take in consideration 2025 AL 008841, give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Norma, yes. We're off the record. How old are you?
24.
44?
Yes, ma'am.
All right. Do you want to spend the rest of your life in prison or in jail?
No, ma'am.
Then you need to stop doing this. This whole thing, from what I've read in the police report, there's zero excuses for it. Sometimes we'll say, oh, I did this because I'm addicted to drugs. There's still really no excuse. It's you took certain actions. So whatever is going on in your life, if you need help with drug addiction, there are plenty of places that will help you. But nobody can help you if you do not want to help yourself. If you want to spend the rest of your life at the Bexar County Jail or at the prison, guess what? There will always be room to accommodate you. If they're at the Bexar County Jail, if that jail only is allowed to hold 1,000 people by law, guess what? If they need to put 2,000 people at the Bexar County Jail, they're going to put 2,000 people at the Bexar County Jail. The prison. If the prison legally can only hold 10,000 people at the prison, do you think they're going to say, oh, well, let's not put anybody else in prison because we have 10,000 people here and no one else will fit? They're going to make accommodations for you. And there is always money in everybody's budget to build another prison if need be, to keep people at the prison. And you know, when people are at the jail and at prison saying it's too cold, nobody cares. Oh, I only got 2 minutes to shower. Nobody cares. Oh, guess what? They're doing laundry and I need the detergent for sensitive skin. Nobody cares. Oh, there's a brown recluse spider at the jail. Nobody cares. And that's just the way it is. I'm not in charge of at the jail. Do I care? Yes. I had a client who was at the Bexar County Jail once, got bit by a brown recluse spider. I go visit them at the jail. They have a hole in their leg. I'm like, what's going on here? And guess what? They got bit by a spider. Do you think they closed the jail down and said, oh, we're going to have to close this jail down. Let's move them to a nice hotel or a budget 6 or whatever. Let's get somebody to come over and fumigate it. No. So you have choices to make. If you want to spend the rest of your life at the prison or the jail, there's always room to accommodate you. Good luck to you.
Thank you, ma'am.
You're welcome.
And now, it is time, my children. The audio is audacious. The production quality is putrid. But now, it is time. It is time to make your sacrifice, where the rulings are final and the sentences are forever. I present you with Dungeon Court.
Your Honor, we're going to need a sentence for another pretrial. Haven't had the opportunity to talk to Mr. Young about exactly what we're going to do. So if we can sentence for another pretrial, let me talk to you. Okay.
Yeah, the preference for a day is going to be in December.
Okay. Maybe approach for a second, Your Honor.
Yes.
Oh, it's a 21.
Yeah, it's 21. I'll like send me periodic like this email saying, and summarize it. One of the markets are, I'll come down and watch and see what we do with cases. Yeah, they don't even have to leave Congress. They're watching. But they're welcome to come down anytime. They may know we're always coming. It's like when I got sworn in the first time, I went out there with my certificate to get sworn in. Secretary of State's office. She asked me, where is it? So, aren't y'all coffee? I said, I'm an hour and a half south of Sort of coffee. And I said, I didn't know there was anything an hour and a half south of Sort of coffee.
For those of you wondering, this is our Friday guilty pleasure here at TCF. It is we go here because it is just the most unusual courtroom. It is the most Soviet style or I don't know, pre-industrial age style courtroom that there is, with the most fitting judge, and we call it Dungeon Court for the obvious reasons. It's dark, it's dank. And it looks like it does. The audio is terrible. We know that. That's why we like it. So those of you that are new here, that's why we call it Dungeon Court. But I just thought I would clear that up for you while Judge Capper, that's the judge, Judge Capper's waiting for, or they're getting somebody else, another contestant to come on up there. Wow, there's lots of jump scare sounds in here too, by the way, so just be aware of that.
That would be the 21st.
Yeah, that's acceptable. Your
Also,
Honor.
Barbara, thank you.
All right, this case
Hold
is
on.
continued.
Also, Barbara, thank you. I can't hear me. Also, Barbara, thank you for the $5, the super chat. Really do appreciate that. I must check on the dogs downstairs, but don't worry, I am attached by my soul to Dungeon Court, so I will be right back in a moment.
State of Ohio versus Amy Slaughter, case number CRB 25391, A, B, and C. State of Ohio versus Walter Slaughter, case number CRB 25390, A and B.
This is Mr. Stratton and Mr. Steyer. Mr. Stratton has Amy Slaughter, Mr. Steyer has Robert Slaughter.
Yes, Your Honor. Mr. Stein?
Your Honor, we worked these out. We had originally been set for a trial this afternoon, but Mr. Slaughter has agreed to an offer made by the state, which is that in return for a plea of guilty to the pending charges, the state and defense would jointly recommend a sentence of 30 days in jail suspended and 2 years of probation, and in order to stay away from the alleged victim. So I guess there's not actually an alleged victim in my case, but he's going to agree to stay away from the alleged victim in Mrs. Slaughter's case.
Yes, sir. And what's that name?
I don't have the name.
Is
Is that right?
I don't have the name off the top.
Because the name's not in my file.
Could you say it again?
The name is, the initials are J.M.
J.M., okay.
Yes. Yes.
Your Honor, the same thing applies for Ms. Slaughter.
Now, is this going to dispose of all the cases? Because there are more than one case here.
Yes.
Yes.
A, B, and C.
Yes. It's a no contest, a guilty plea to all three, Your Honor.
And there's an A and a B in Mr. Slaughter's case, I believe. I don't think there's a C in his. Or B if there is.
All right, Mr. and Mrs. Slaughter, do you agree with what your lawyers are telling the court?
Yes, sir.
You have a right to make statements to the court if you want. Do you have any statement or explanation or allocution
No, sir.
that you would like to make?
No.
Okay. Mr. Steyer always says no. He's always saying he doesn't want people to say. You want to say something?
I would like to, Your Honor, on behalf of the state. The victim and her mother in this case would have been here today for trial. They've been subpoenaed and they expected to be here at noon, except that the mother felt that it was the best interest of her daughter to not have to testify in this, so that's the reason why we agreed to. We were, our recommendation would have been some jail time for both of them, but because of the fact that we wanted to honor the wishes of the victim's mother in this, and that she was better off not having to testify, we'd agreed to no imposition of jail time, just a suspended sentence.
Okay. So there's going to be a no contact order, and is that going to be hard for you to comply with? Or?
I don't think there's any reason that should be an issue.
Okay. All right, so let's start with Robert Slaughter. The A case, we'll impose a $100 fine, order the cost be paid, 30 days in jail, suspended.
not through your daughter.
Was there community service recommended on this?
Didn't make that recommendation, but didn't really make any statement about that at all.
All right, I'll make it 0 hours community service, 2 years probation, no contact order with J.M. as the person, minor. Set the review hearing for May 15th.
It'll be the same one for both of you.
Disorderly conduct, $50 fine. I think that's all we need to same review date.
So you need to step out, go to Mr.
So now we're to Mrs. Slaughter, Amy Slaughter.
Yes.
On the assault, $150 fine, cost 30 days in jail, suspended, no community service, 2 years probation, no contact with J.M. Review hearing May 15th.
He wrote it down too.
B case, $50 fine. And she had a C case, I think. Yeah, C case. $50 fine. May 15th is the review hearing on all cases.
All right. We just need the probation. He should already be there. All right, thank you.
You are.
State of Ohio versus Michael P. Fuller, case number CRB 25-721, set for arraignment, Your Honor.
This is an arraignment. And sir, you're Michael Fuller?
Yes, sir.
Dale's just handed you a copy of the charge. It's a menacing charge. It alleges that at Union Township on November 4th, you knowingly caused Dirk McFan to believe you would cause physical harm to his person or property. That's a 4th degree misdemeanor, maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
Yes, sir.
And I don't know if you were here when I explained the rights defendants have. Do you want me to go over that again, or did you hear it? Do you have any questions about your rights?
No, sir.
How do you plead to this charge?
Guilty.
Guilty means you're admitting it's true. You're
Yes, sir.
waiving your right to have a trial, to have a lawyer when you enter a guilty plea. You understand that?
Yes, sir.
Okay, let's turn to the prosecutor. Do you have a report on this? Mr. Hill, do you want to place in the record?
Yes, Your Honor, and this is from Deputy Shope of the Lawrence County Sheriff's Office. November 4th, 2025, I responded to a report of ongoing harassment and threats involving Dirk McFan and his neighbor Michael Fuller at 235 Township Road, 1348 Chesapeake. Upon arrival, I made contact with the reporting party, identified as Dirk McFan, who provided a voluntary written statement. According to Mr. McFan's statement, his neighbor, Michael Fuller, had continued to harass, stalk, threaten, harm, and also threaten my life. Mr. McFan stated that the most recent incident occurred around 1400 hours on November 4th, 2025, and he captured video footage from the confrontation. He further indicated that I viewed the video footage during the investigation and that the events were recorded on my department-issued body camera. After reviewing the video, I observed Michael Fuller approach Mr. McFan aggressively. Fuller attempted to strike McFan and then stated for McFan to step out into the road and settle it like men, based on the video evidence and statements. Michael Fuller was placed under arrest, transported to the Lawrence County Sheriff's Office, and booked on the charge of menacing.
All right, Mr. Fuller, do you have an explanation for this?
Yes, sir. We've haven't gotten along for the past 4 years.
You say you have or have?
Have not.
I've got a court date coming up Tuesday, and we're taking it to court in Ironton. The judge did not grant him anything because there was some insignificant evidence on his video camera. So I have court Tuesday morning in Ironton. We just been having a lot of problems. He came at me, he pulled up, I got people that's witnesses. He pulled up squealing his tires. He pulled on my property, backed out. When he got out of the truck, he flipped me off. So I told him, let's do this like men, leave the cops out of it. This is bullcrap, you have a problem with me. And immediately, he come down to the edge of his driveway, flipped me off to my face, called me a bunch of derogatory names. So yes, sir, I did say, step out in the road so I'm not gonna be on your property. Well, when he came down there to the very end of his driveway, he reared back like this, and it's on camera. He reared back like this and was stepping towards me. I was standing out in the middle of the road trying to get him to come out. And when I did, I was going to defend myself. And that's when my wife stepped in, and my wife told me to leave it alone.
Well, why'd you enter a guilty plea? Because you're kind of telling me that you felt like you had a right to defend yourself, or you were provoked, or...
Well, I mean, I was provoked and I jumped on it, and I shouldn't have. So that is my guiltiness out of that.
What's the case in Ironton about?
We're taking it to trial in Ironton.
About what?
All this stuff that's going on.
Is it a protection order?
I didn't hear you.
Somebody's asking for a protection order?
Yeah, it was already posted, and Darren Hamlin came out and explained to me what was going on yesterday.
Do you have a lawyer that's representing you in Ironton?
I'm getting one.
We're okay to delay sentencing and have the alleged victim here and sort things out.
Okay. So this is what I'm going to do. I'm putting it down for a guilty plea, but I'm sure if you talk to the lawyer, they may want you to withdraw that. It was an uncounseled plea. You don't have a lawyer with you today. So maybe when you talk to the lawyer about the case in Ironton, you probably need to discuss this one too. So anyway, I'm going to set it. When's your case set?
Tuesday the 12th.
Okay, so we need to come back after that and see what happened down there. Well, they're all about the same. Let's do the 21st. I'll set your next hearing here for the 21st. I'll put it as a sentencing. But if you hire a lawyer, they're probably going to ask you to withdraw the plea, which you allow when it's uncounseled. If you don't have a lawyer near a plea and then you ask to withdraw at the lawyer's suggestion, I probably would allow that.
At what time, sir?
It'll be at 10 o'clock. I'm going to let you sign a signature bond of $1,000.
Yes, sir.
I'm going to order you to stay away from this, what's the guy's name?
Dirk McMahon.
McFan, stay away from him, even though he's a neighbor. So you guys don't need to go around or talk to each other while this is finished.
Yes, sir. That's what Mr. Hamlin explained to me yesterday. Yes, sir.
Oh, you have a bond up? Okay.
Yes, I've already
I'll just
posted.
continue the bond that you have. It's continued.
Yes, sir.
You're under a bond now, so
Yes, sir.
just don't let anything else happen.
Absolutely. Yes, sir.
State of Ohio versus Bryce.
Hey, you, let's fight. Them's fighting words.
2808 A and B, Bryce McGinnis.
We're in Dungeon Court. It's TCF. It's Friday. It's our guilty pleasure. We're just kind of hanging out here through the end of the show in Dungeon Court.
Okay, this should be. It's okay, it's under. This is filed under a DUI suspension. Okay, you're Bryce McGinnis?
Yes, sir.
Mr. McGinnis, it's alleged that on November the 3rd at 7:30 a.m., Perry Township, you were operating a motor vehicle while you were under an ODI suspension. That's a first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. The minimum penalty is 3 days in jail and $250 with failing to control your vehicle. That's a minor misdemeanor, maximum penalty is $150 fine. You understand these two charges?
Yes, sir.
How do you plead to these charges?
The failure to control, guilty. The other one, I was coming back from work, and I have driving privileges to come back and forth to work. It was late, so that's the only reason I was out at the time was work. It's coming back.
Okay, I'll enter a not guilty plea for you.
Thank you.
Okay. I'm entering a not guilty plea. Do you wish to be considered for a court-appointed lawyer?
Yes, sir.
Are you working?
Yes, sir.
What do you do?
I pressure wash with my father.
I'm sorry.
I pressure wash.
Okay. I have to determine your gross annual income. What, are you paid by the hour?
Yes, sir.
How much per hour?
$12 an hour.
How many hours a week?
Anywhere from 20 to 30.
I'll appoint Mr. Steyer to represent you. I'll set a $1,500 signature line.
Your Honor, will he need fingerprinted?
He will indeed be fingerprinted. And I'm going to set, I can set this the 17th or after of November.
'24th, Your Honor?
Yes, that's fine. November 24th, will be the next hearing.
November 24th, 10 a.m. Thank you, Your Honor.
Okay, and just a reminder, if you're driving under a permit, if you're only permitted to drive for the circumstances on the permit. Okay, November 24th, not prejudged in this case, but November 24th, 10 o'clock.
Your Honor, we're ready to call the inmates that are left in holding.
Okay, we have prisoners in the holding cell that have cases, and we're going to call those now.
State of Ohio versus Roy Bentley, number CRB 18877. This is Mr. Morford's case, Your Honor.
Roy Bentley. Okay, we need the agenda in the courtroom, we need Mr. Morford in the courtroom.
It looks like it was a failure to appear for a review hearing. I don't know if it's
Okay, probably not, it was a review. So we don't need Mr. Morford, we just need Mr. Bentley. Roy Bentley. Hey, sir, are you Roy Bentley?
Yes, sir, I am.
Mr. Bentley, it's alleged that you had a conviction in this court on a theft offense and had a review hearing scheduled for June the 16th of 23 that you didn't appear for. A warrant's been outstanding since June 23rd of 23. Do you admit or deny you missed your hearing?
I don't deny, sir. I didn't know I had it, but I've been incarcerated in Kentucky for 4 years and just made parole. I didn't even know I had it for then.
How did you get in custody now? Did you get arrested on this warrant, or were you transferred from Kentucky to?
I was transferred from Kentucky. This is what we were born here.
And you got something out of common pleas too, or?
I'm not sure.
Are you going to be living here in Lawrence County now?
Yeah.
Where?
1989 County Road 56.
Okay, that's the same address you gave me back in 2018, so that's the old home place?
Yeah.
Well, do you want to take care of this, or you want to lay it out in jail?
Well, how long can you give me back? How much is it?
You got $410 because you had some restitution to pay for a lawnmower, and you had fines. You had $200 restitution to Kyle Poplin, that was never paid. You had a fine, court costs, so the total is $410 plus 5 days of community service.
Can you give me time to pay it, let me make monthly payment?
Yes, sir. If you will, here's what I'm going to do. I'll withdraw the warrant. So I don't know if you've got a warrant from another court, I can't withdraw that, but I'll withdraw this court's warrant, give you another review date, and you have to come to court then. Or if you don't, we're going to do this again.
I don't do this again, let's be done with it.
So to make it easy to remember, I'm going to set you for December 1st. December 1st, first day of December. You got to be right back here for a review at 9 o'clock. Unless you pay off all your fines and done your community service. But I'll just set for review hearings. As long as you're working on getting it done, I'll keep giving you time reasonably, you're making a reasonable effort until you get it finished. And then you don't have to go to jail.
Great, sounds good, sir.
Okay, December 1st, we'll see you then. Work on this. You can do community service. Are you closer to Iron Municipal than here, or where?
I'm in the middle, close to that.
Okay, we'll just come here then. Any morning at 7:30 except Sunday, you can come here to do community service. Or a holiday. It's a holiday, you can't come, but if it's a regular business day or Saturday, you can come here 7:30 a.m. to do community service.
How much community service I have to do?
30 hours, 5 days.
All right, thank you, sir.
You're welcome.
State of Ohio versus Ian Brown, case number CRA 25717, CRA 25719, CRA 25707 A and C, CRB 25350.
So are you Ian Brown? Okay, Mr. Brown, let me explain your rights to you. You have a right to remain silent. You don't have to say anything. What you're saying goes on the record, so it can be used against you if you admit something. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove the charges against you beyond a reasonable doubt. You understand? Yes, sir. You got some new charges and you got one old charge, so we'll go over the new ones first. 25717 is a new charge. Possession of a fentanyl-related compound. And it alleges that on November the 5th in Peary Township, you knowingly obtained, possessed, or used a controlled substance containing fentanyl. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. And then at the same time, same date and place, you're charged with obstructing official business that you, without the right to do so, purposely prevented, delayed, or obstructed the performance of a public official of their authorized official duties. That's a 2nd degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. So So those are new charges. And then there's another set of new charges, 25, 706, and 707. 706 alleges that on October 28th this year in Union Township, you knowingly caused or tried to cause physical harm to Emily Hay, and that Emily either is a member of your household or a member of your family. So that makes it a domestic violence charge. Maximum penalty for that is 6 months in jail, $1,000 fine. 707A, also October 28th. And this one's Union Township. It's alleged that then, in Union Township on October 28th, you trespass in an occupied structure with the purpose of committing a criminal offense in that structure. So that's burglary, it's a felony of the first degree, carries a maximum penalty of 10 years in jail and $20,000 fine. 707B, same time and place, Union Township, October 28th. You knowingly created a substantial risk of serious physical harm to another person, that's alleged to be Emily Hay, by means of strangulation or suffocation. That's a felony of the third degree. Maximum penalty is 5 years in jail, $8,000 fine. 707C is disrupting public services. And that alleges the same day, October 28th, Union Township, you purposely and knowingly damaged or tampered or impaired some sort of communication device, usually it's a phone. And that is a felony 4. Maximum penalty is 18 months in jail and a $5,000 fine. So those are all the charges from October 28th of this year. Then we've got case number 25350. And this was a case that's still, well, actually you were sentenced on this. It was a criminal damaging charge. And you were sentenced on July the 18th for criminal damaging in order to pay restitution to Emily Hay. $200.
Looks like there's a probation violation issued on that.
Okay, thank you. So you have no contact order was issued as to Emily Hay. She came in on September 15th and asked if the no contact order be dropped. But then a probation violation was filed. With regard to these charges, that you did not report to probation on September 17th, 2025. That was the reason for the probation violation. So that's still clear. So, do you understand these charges?
Yes, sir.
Do you have the money to hire a lawyer?
Yes, sir.
Do you have a job?
Yes, sir.
Do you have no income at all? All right. I'll appoint Mr. Steyer to represent you. This is Ian Brown, and he has several charges. The most serious are burglary and strangulation. Those are felonies. What's the state's position on bond?
State would request a $75,000 cash assurance.
So I'll set that for now, let you talk with him. If you want me to reconsider it, I'll do it later. 75,000 cash for surety. That will cover all charges.
here Friday, Your Honor. I would ask that we set them back for the 14th for preliminary hearing based on the amount of bond. If I talk to them here, something else we can do, like extend that, but maybe ask them to change it if we know it, because that's time set.
I'll set preliminary hearing for November 14th. 10 o'clock. And there is a probation violation on this one, so it'll be a pre-trial. And I'm assuming you'd like to have the files to discuss the case of Mr. Brown, so if you want, have it recall this other day.
Thank you.
State of Ohio versus Heather Gilpin. Case number CRA 254401, CRB 25442. Excuse me, 442. Mr. Moore for the case.
Heather Gilpin is, well, it's actually a bond revocation. She got treatment, which was a condition of her bond. She was at Bethesda, left treatment without approval of the court. She is in custody. Okay, do you wish to speak with her, Mr. Marker, before we proceed any further?
Yes, please, Judge.
Okay. You might want to talk with Mr. Major. I'll let you have the court's file when you're ready to have it called up. Let the bailiff know.
Thank you, Judge.
You're welcome.
State of Ohio versus Marion J. Holland. Case number CRB 25720.
This looks like a new charge. And you, sir, you're Marion J. Holland?
Yes, sir.
Mr. Holland, I'm Judge Caffer. This is an arraignment hearing for you. I'm going to go with your rights first and then your charges. You have a right to remain silent. You don't have to say anything. If you do make statements, it's all being recorded and it can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail and to make the state of Ohio approve the charge against you beyond a reasonable doubt. You understand those things?
Yes, sir.
Okay, the charge filed against you is aggravated menacing. It's alleging that at Fayette Township, November the 5th of this year, you knowingly caused Sandra Wood to believe you would cause serious physical harm to her person or to her property. That's a first-degree misdemeanor. It carries a maximum penalty of 6 months in jail and $1,000 fine. Do you understand
Yes,
the
sir.
charges? And you understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
You want a lawyer appointed to represent you? You have a job?
No, sir.
You have no income?
No, sir.
I'll appoint Mr. Stratton to represent you. Entering a not guilty plea for Mr. Holland. State's position on bond.
The state does not oppose an OR bond, but we are asking for a protection order.
Any problem with you staying away from Sandra?
No, sir.
You all don't? Okay, you don't live together or anything like that. Okay, you just have to stay away, don't contact her. Don't post anything on social media about her, okay? That's something I have to say now.
It's good advice, Judge. It's Dungeon Court.
Okay, so I'm gonna let you sign a $1,000 signature bond.
It's TCF Live on a Friday. We're just hanging out here for a few more minutes. TCF Live overtime.
We're looking at 21st or after November, Mr. Stratton?
Any day except the 24th here.
Okay, let's do the 21st. November 21st for pretrial, 10 o'clock. So you'll get out of your promise to be in court and stay away from Sandalwood. Back here the 21st, 10 o'clock. Sure.
State of Ohio versus Corey J. Hudson, case number CRB 25718.
Sir, are you Corey Hudson? That officer just gave you a copy of the charges. I looked over those with you. Before I do that, make sure you understand your rights. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make a mistake, prove this charge beyond a reasonable doubt. You understand those things? The charge is falsification. It alleges that on November the 7th, in Fayette Township, you knowingly made a false statement or swore from the truth of a false statement you made previously with the purpose to mislead a public official and performing their official duties. So that's a first degree misdemeanor. It's a maximum penalty of 6 months in jail, $1,000 fine. You understand that charge? All right, do you have any questions before you enter a plea to this charge?
Yeah, I was hoping to be sentenced to that's why I did what I did.
Okay, well, you're putting the cart before the horse a little bit. I gave a plea from you first, so you ready to enter a plea? What plea do you want to enter?
No contest.
No contest means I'm not admitting it's true, but I'm not denying it either. And Judge, if you think what the state says it has as evidence is legally enough to convict me, you can find me guilty without a trial and order. That's what no contest means. So 99% of the time, it results in a guilty finding. You want to plead guilty. That means you're admitting it's true. You understand that? Okay. I'll accept your guilty plea. You want to give me your report, Mr. Young?
Yes, Your Honor. This is from Sergeant Perry Atkins from the Lawrence County Sheriff's Office. Friday, November 7th, 2025, I was dispatched to 165 Township Road 1335, Apartment 5, and that's the South Point, in reference to a 911 hang-up call. While arriving, dispatch advised a male had called back and stated the call was accidental. I arrived on scene with Trooper Chris Jewell. I advised dispatch that we would be making contact to confirm the welfare of the occupants. Myself and Trooper Jewell entered the building and remained briefly in the hallway to listen for any signs of distress. I heard a male voice inside apartment 6 speaking to someone, stating he was cleaning his phone and accidentally called 911. I knocked on the door, at which time the voice inside became quiet. I asked dispatch to call the number back and request that the male please answer the door to speak with me. A short time later, the male opened the door and was identified as Kenny Holtzapple. I explained the nature of the call and advised that on 911 hang-ups and possible domestic-related calls, I prefer to visually check the welfare of anyone present. Kenny stated he understood and permitted myself and Trooper Jewell to enter. Once inside, Kenny again stated he accidentally dialed 911 while cleaning his phone. I asked if anyone else was in the apartment, and he stated his friend Corey should be lying down on Kenny's bed. I looked into the bedroom adjacent to the living room and observed the bed to be empty. When I asked again about Corey's location, Kenny stated he was unsure and suggested Corey may have left. I called out for Corey and heard movement coming from a closet inside in the dark. A male then exited the closet. I immediately observed a knife on his hip. For safety, I removed it during our encounter. I explained to the male the reason for our presence and requested his name and date of birth. He identified himself as Corey J. Thompson, date of birth October 19, 1986, and stated he formerly lived in New York and now lived in West Virginia. He acknowledged a prior drug possession arrest in New York and stated he previously had an ID there. I requested dispatch to check New York, West Virginia, and Ohio, and Leeds, and NCIC. Dispatch reported no record found. The male then provided a social security number, which also returned no results. No CCH record was found in any system. Based on the male's statement of prior arrest and continued inability to confirm his identity, I believed he was deliberately providing false identifying information to avoid arrest on possible warrants. I advised him he would be detained while attempting to verify his identity. Once handcuffed, the male stated his actual name was Corey J. Hudson and that his correct social gives his social. He further stated he believed that he had an active warrant or active warrants in Campbell County, West Virginia, I suppose that's Cabell County, for breaking and entering and receiving stolen property. Corey stated he was only attempting to avoid arrest for a couple of days so he could get into OVP for treatment. I requested dispatch check the new identifying information. No system return was located. However, dispatch contacted Western Regional Jail in West Virginia. Western Regional advised that they did have a record of Corey Hudson and agreed to send booking information and a mugshot to our agency. Corey Hudson was placed under arrest for providing false information to a peace officer and transported to Lawrence County Jail, where he was lodged without incident. Body-worn camera footage was activated and recorded to my contact with Kenny Holtzapple and Corey Hudson throughout the incident.
So this here is their mind, warrant for him out of West Virginia.
This didn't make that clear. I don't know if our jailer knows that. I'm sorry?
I haven't heard anyone swear by double check. Yeah, I think it doesn't make sense why he would hide out. I mean, maybe he thought he had a warrant. Let's check and make sure, because sometimes things don't get entered like they should. So I'll call you in the docket. We're going to be here for a while. See if you have a warrant out of West Virginia. So I'll recall you later.
State of Ohio versus Brianna Maynard, case number CRB 25548.
This is Mr. Steyer's case, Brianna Maynard. It's set for a pre-trial today.
Your Honor, I believe he was in fact with an
In the witness room?
He did move over in.
I think Mr. Steyer's back there in the witness room. Did you tell him also that his client's out in the courtroom? You can just stand out here, man. Here he is. He's out here.
I'm sorry.
This is Brianna Maynard, I think that's your client?
Yes.
Set for pre-trial.
She was set for sentencing on Wednesday. The entry has not been put on. She says 5.5 years in prison. I don't know what state we've discussed this. I think
This is a 4th-degree misdemeanor domestic violence.
in my understanding, I don't believe the victim was all that interested in it, but
Yes, and we'd agreed to nolly the charge, provided that she was disposed of in common police court.
All right, so the charge here will be nollied. You'll just have to serve the sentence out of common police.
thank you.
You're welcome.
State of Ohio versus Carrie Beth McCoy, case number CRB 24227.
It's a super jam-packed version of Overtime, TCF Live, Dungeon Court. We'll hang with it till the bottom of the hour. We'll call it a day thereafter. And we're having fun. We're hanging out, and then we'll welcome Dan back on Monday.
So are we back on, is this 30 days, and the entry said 30 days, she could ask to go to treatment? Is that what she's asking for? Will anyone take her? I mean, that's the issue we have, is that she's maybe worn out of welcome at a few places. Do we got any agencies that are willing to consider Ms. McCoy for treatment?
Let me make a call, get right back with you.
All right, what agency are you with? I'm sorry.
Mandy Goshen.
Okay. All right, we'll recall you later. Goodbye.
State of Ohio versus David Vance, case numbers CRA 25723, CRA 25722, CRB 2550, CRB 24597, CRC 241921, A, B, C, and D.
All right, you're David A. Vance. All right, Mr. Vance, I'm Judge Capper. This is arraignment for you. You have a right to remain silent. You don't have to say anything. If you do make statements that can be used against you, you have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove these charges beyond a reasonable doubt. You understand those rights? Now, you've got some new charges and there's some old charges, so I'm going to go over the new ones first. 25, 722, and 723. 25, 722 alleges that on November the 7th, in Fayette Township, knowingly caused or tried to cause serious physical harm to Cassidy Elaine Mullins by strangulation or suffocation. That's a felony of the 3rd degree. The maximum penalty for that is 5 years in jail and a $10,000 fine. CRB 25-723 alleges that on November 7th this year, Fayette Township, you knowingly caused or tried to cause physical harm to Cassidy Mullins, who's a member of your household or family. That carries a maximum penalty of 6 months in jail and $1,000 fine. Then there's pending charges. Well, actually, review. These are all completed cases, so it's alleged on these that you had failed to appear for a review hearing. 2550. That was a menacing charge, and we had a review hearing October 20th of this year at 9 a.m. It's like you didn't show up for that. Warrant was issued. 24-597. That was an endangering children charge. We had a review hearing for it on October 20th of this year. It's like you didn't show up. 24-1921 was an OVI conviction. So as you had, it was set for review hearing October 20th, you didn't show up. So warrants were already outstanding on those charges, and then you got the new charges. Do you understand those things? You have the money to hire a lawyer. You have a job. You have any income.
I just got told I could go back to work. I haven't put in an application for it. I had surgery on August. I just haven't found a job yet.
Okay. All right, Mr. Morford, I'll appoint you to represent Mr. Vance. So on the new charges and also on pretrial review for failure to appear on the old charges. What's the state's position on bond for Mr. Vance?
Well, Your Honor, let's see. We just had him in court recently.
We missed a hearing. He was supposed to be here for review in October and didn't come on those matters, and now he's got the new charges.
And this is a serious charge. We'd asked for a $25,000 cash surety bond and a protection order.
Okay, I'll set on at $25,000 cash for surety. That'll cover everything with a protection order to stay away from Cassidy Mullins. Is that a bond you think you can post, Mr. Vance? Well, you can pay it, and then if you do that, you get all your money back if you show up for all your hearings at the end of the day. You can't pay the $25,000. You can hire, basically you're hiring somebody else to guarantee your appearance, and that bail bondsman then is responsible for the $25,000 if you don't show up. And usually it's around 10% you pay them, that you lose that, they keep that money.
That would be 10%.
2,500. You want to talk to a bail bondsman then?
Yeah.
Mr. Morford can get you in touch with the bail bondsman.
Oh, okay. Here.
So when do you want to come back for a hearing? When did you came in the jail today? So we could do Friday or the 17th would be Monday.
Got down here the 14th.
Okay. November 14th will be the next hearing for Mr. Vance on everything. All his cases are set for November 14th. Preliminary hearings, pre-trial review.
Thank you, Your Honor.
You're welcome.
Wow. They pretty much instantly got him that. Some of those crimes he committed just today. My goodness. And he had a laundry list. We had a couple people with a laundry list of crimes there in Dungeon Court. Kind of an interesting edition of Dungeon Court today. It's always interesting, but today, I don't know, must be the full moon we had this week. Anyway, well, we have reached that time, my friends. And, well, that's weird. Hey, that's a new look. What is that? What's going on there? Wait, what? How did I do that? All right. Well, anyway, we have reached that magical time. I don't know how I did that. Where that's it. We're done. And I really do appreciate you guys hanging out and spending time with me here for the last couple of weeks. That is weird. I don't know how I did that or why it's like that. It's what's that called? Like I don't know. That is very strange. Well, in any event, it has been fun. Lots of fun and frivolity and hijinks and all sorts of stuff. And I really appreciate you supporting me, helping out. This has been fabulous. I have had a great 2 weeks filling in for Dan, and technical issues, notwithstanding and all of that. This has been a great time, and I thank you guys, all of you, for your support, your super chats, your super stickers, all of that really helps us out here. I'll just go back to this because I'm getting weirded out by that. I don't know why that's, I broke something in StreamYard. I'll have to fix it later. But in any event, you guys, I really do appreciate it. Your super chats, your super stickers, your support in the chat. Joining us on Sidebar. I've been hosting here for the last couple of weeks, filling in for Dan. And I want to say this before we get out of here. A speedy recovery to Beth, Dan's wife. She fell, she broke her leg. That's pretty much all we know. It's anytime you break your leg, it's not pretty. It's going to be quite a lengthy recovery for Beth. We know that. They're still in Utah, but they are making their way back here eventually. Now, of course, if needed, I'm on the bench. I'm always ready to go and step in and host. But all things being equal, everything notwithstanding, I think Dan will be back here on Monday. Tuesday, even though it's a holiday, we probably won't have TCF live, but we will have Sidebar Tuesday night at 8 p.m. East, 5 p.m. Pacific. So please join us for that. And once again, thank you guys so much for all of your support. So let me just say this again. Thank you, Barbara, Bailey, Ashley, Lindsay, Austin, Wahoo, a couple of people from my community, from my channel, David Nielsen for one, I know, and a couple other people from my channel have stopped on over here to say hello. Mama Joan, Grandma TCF, of course, the one and only Michelle, who has been executive producer today. She's the executive producer in absentia. And just everybody, all of you guys, you drive this ship. I just press the buttons and do all this stuff and make all that happen. But I really do appreciate it. All right, Monday morning, 10 a.m. East, 7 a.m. Pacific, 45 minutes early for channel members. Dan will be back here, so please join him. And but if you do feel like letting him know that I did an okay job, hey, feel free. All right. Have a great weekend, everybody. Please be safe. We've had enough accidents and incidents. I have my back. There's something wrong with my back. I know Lindsay was under the weather this week. Bailey's going through stuff. Over here we got water heater issues. We got all sorts of stuff. Everybody's having some stuff. So let's try to be safe and come back on Monday morning. Until then, Michael Groff saying thank you so much. Have a great weekend. Goodbye, everybody.